ಎಲ್ಲ ಕಮ್ಮಿ ಆಗಿದೆ. ಕಂಪ್ಲೇಂಟ್ ಯೂಸ್ ಮಾಡ್ತಾರಲ್ಲ ಅದಕ್ಕೆ. ನಾಳೆ salary ಊಟನೇ ಮಾಡೋದ್ ಬೇಡ. ನೆನ್ಸ್ಕೊಂಡ್ರೆ ಬರೋಣ. ಹೌದಾ?
agency.
Huh?
Business premises of the petition have been closed down by the BBMP officials without issuing any notice.
Fresh matter.
Once it has come,
Huh?
notice has been added to the
Ah.
subsequently interim order has not been granted.
If you are not able to convince this court, then no interim order at that stage.
Subsequently,
It has to come up. Yes, only fresh matters you please give.
subsequently the electricity connection also.
Fresh matters today. Please give us fresh matters. Huh? Yen election matter. It will come up tomorrow. Please give.
Proceedings pending by the corporation against the petitioner, and we were in possession. The day before yesterday, they came and started knocking off the premises. I just wanted to
Fresh matter. Let it come tomorrow. What is, sir? Please give. Let it
Fresh
come
matter with
tomorrow.
respect to the elections. Tomorrow, my lords. Tomorrow, my lords.
What is? Fresh matter, sir. What is?
Where respondent number 6 is putting up the construction of apartment adjacent to my property. Perhaps he has think about 40 feet below Maras, due to which perhaps my building, which is adjacent to the property, where the construction is carried out, perhaps it is shrinking. Perhaps this one report had directed both the parties to work out a amicable solution and permitted them to carry on construction.
ಅದಕ್ಕೆ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ವ ನಾವು?
4th ತಾರೀಕು ಕೊಟ್ಟಿದ್ರು. Because on 36/2001 earlier council, took time. Later on because listed for 1 week and due to.
What is? Please give. Yes.
Tomorrow or Friday, my lords.
Well, it's the petitioners and the
Most
respondent.
conduct.
The petitioners and respondents had entered into a joint development agreement. with us.
What do you want?
My
If
lords,
it is a fresh matter, you please give.
it's a pending matter.
Pending matter ಆದಾಗ ಆಗೋದಿಲ್ಲ. You have to file an application showing cause why it has to be listed early. Yes. Adjournments only if the other side is here and says no objection. Informed ಆಗಲ್ಲ. Yes. Huh? Where is the list?
Page number 17. Then the relevant portion of the.
This is the list of eligible voters.
My membership is 150 marks.
If your name is not contained in the eligible voters list, it's a different thing. If they have put up a disqualified voters list, then you will stand on the same footing as the others.
ನನ್ನ membership ಗೆ ಬೇರೆ ಹೆಸರು include ಮಾಡಿ.
Huh?
I kindly see.
That cannot be challenged by way of a writ petition. That cannot be challenged by way of a writ petition.
My membership may kindly steer actually.
Sir, how to decide all this now? There are other authorities who are there under the statutes. Please go before them. ನೀವು ಡೈರೆಕ್ಟ್ ಆಗಲ್ಲ ಇದಕ್ಕೆಲ್ಲ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರೆ ಅರ್ಥ ಏನು? Is there no other provision where you can bring it to the notice of the higher authorities? Then you will have to move them in accordance with law, not contacting them over phone. You will have to file a petition, sir. ಹಂಗಲ್ಲ ಆಗೋದಿಲ್ಲ. ಅದು ಬೇರೆ. That is why I asked you, is there any list of disqualified members? ಮತ್ತೆ
No disqualified members. My membership.
ಆಗೋದಿಲ್ಲ.
Page number 19 may kindly see. Survey serial number 37.
Nothing can be done.
Serial Mundraju Mundreddy has been inserted as the voter. He is nowhere a vendor.
ಹಂಗಲ್ಲ. It is not. If there is any discrepancy in the voters list, then you will have to go before the competent authority. That matter was a case where a list was announced saying all these are disqualified, and the coordinate bench found that such disqualification without issuance of individual notices cannot be sustained. Therefore, interim orders were passed permitting them to go and participate in the election. Idral agadilla. Agadilla. Learned HCDP. ATA takes notice for response number 1 to 3 and 5. The emergent notice to respond number 4. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. ಮಾಡಿದ್ರು ಅಷ್ಟೇ ಮಾಡದೇ ಇದ್ರು ಅಷ್ಟೇ ಪ್ರಯೋಜನ ಆಗೋದಿಲ್ಲ. Yes, sir. Where is that ineligible voters list?
B is ineligible. B1 is eligible. 22.
ಅನರ್ಹ ಮತದಾರರ ಪಟ್ಟಿ. When was it announced? Date ಇಲ್ಲ. When is the election scheduled to be held? Huh?
27 is election.
Next Sunday. So the time for filing nomination papers are all over. So only for casting the votes. Same orders. Huh? ನೆನ್ನೆ ಒಂದು ಮಾಡಿದ್ವಲ್ಲ. Only for casting votes. AGA takes notice for response number 1 to 3 and 5 and 6. Learned counsel Shri TL Kiran Kumar is requested to take notice for response number 4. Issue emergent notice to respond number 7. Learned counsel for petitioner is directed to serve 2 sets of copies of the petition along with annexures on learned counsel for respond number 4. The copy on the learned AGA. Make it the same.
Raju. Third respond. Owner of front side of the building by license without obtaining any building by license is considered. Kindly note the lecture page 50 the photographs. And the insurer is never left the.
ಏನ್ರಿ ಜಾಗ ಚಿಕ್ಕದಲ್ರಿ ಏನ್ ಮಾಡ್ತಾರ ಅವ್ರು?
And I left 1.5 feet left. Even I have stated in the petition also.
ಆ ಕಡೆ ಪಕ್ಕದ್ದು
That side only. All side, all the corners I left 1.5 feet.
ಎಲ್ರಿ ಬಿಟ್ಟಿದ್ದಾರೆ? ಈ ಪಿಂಕ್ ಸೈಡ್ ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ಜಾಗ?
But we left, even I have stated in the page 49 10 representation.
And it cannot be 1.5 feet.
It is outside. It is outside.
ಹೌದು ಸರ್,
Outside.
ಕರೆಕ್ಟ್. ಕಾನೂನು ಪ್ರಕಾರ ಎಷ್ಟು ಬಿಡ್ಬೇಕು ನೀವು?
3 feet back, 3.5 feet.
ಮತ್ತೆ you are inviting trouble. We will tell, we are telling you, if he makes a complaint against you, we'll take that also into consideration and we'll direct them to proceed against you also. ಮಾಡ್ಕೊಳ್ಳಿ, ನಾವೇನ್ ಮಾಡಕ್ಕೆ. Learned counsel Shri Pawan Kumar, who is present in the court, takes notice for response number 1 and 2. Issue emergent notice to respond number 3. Learned counsel for petitioner is directed to serve 2 sets of copies of the petition along with annexures on learned counsel for the respondent BBM. ಯಾವಾಗ ಕೊಟ್ಟಿದೆ ಕಂಪ್ಲೇಂಟ್ ನೀವು?
That is annexure, not page 49. Annexure G 11/7/2020. Link ಆಗ್ತಿದಂಗೆ you have given page 49.
Next para. It is the grievance of the petitioner that although a complaint was ಈಗ 11/7 ಅಷ್ಟು ಬೇಗ ಓಡ್ ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಾ ನೀವು?
11/7 you have.
ಸ್ವಾಮಿ, ಆ ಪ್ರಾವಿಷನ್ಸ್ ಓದಿದ್ದೀರಾ? They have to issue notice, they have to give them time, ಅಷ್ಟ್ರೊಳಗೆ ಓಡ್ ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಾ ನೀವು. You have given the information complaint on 11/7 and you have already rushed to the court. You think they will be able to proceed and demolish the building in a few weeks without affording opportunity to the other side?
At least not let them start construction. They are not, liability they are putting up.
It is their property, sir. They will put up construction.
Certainly.
The action can be taken only if it is found that it is a violation of the sanction plan. For that purpose, they have to issue notice, give them time, call for objections. ಇವೆಲ್ಲ ಪ್ರೊಸೀಜರ್ ಫಾಲೋ ಮಾಡೋದು ಬೇಡವಾ? ಮಾಡ್ತಾರೆ, ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ರೀ. ಆಮೇಲೆ ಡೆಮಾಲಿಷನ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡ್ಕೊತಾರ ಅವರು. ಅವ್ರು ಕಟ್ಟಿದ್ರೆ ಬಿಲ್ಡಿಂಗ್ ಡೆಮಾಲಿಷ್ ಆಗೋದು ಅವ್ರದ್ದು. ವಾಟ್ ಆರ್ ಯು ಗೋಯಿಂಗ್ ಟು ಲೂಸ್? ಸಿವಿಲ್ ಕೋರ್ಟ್. ನೀವು ಲೈಟ್ ಏರು ಅಂತಂದ್ರೆ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಬರೋದಿಲ್ಲ. ಅಷ್ಟೇ, ಅಷ್ಟು ಮಾತ್ರ. ನೀವು ಲೈಟ್ ಏರು ಅಂತಂದ್ರೆ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗಿ ಅಂತೀವಿ ನಾವು. ಗೊತ್ತಾಯ್ತಾ? Given on 11/7/2023 to the respondent, Assistant Executive Engineer, HSR Subdivision BBMP, bringing to his notice the deviation in the construction of the building contrary to the sanctioned plan. Undertaken by the third respondent, no action is taken. Full stop. Next para, learned counsel for the respondent PPMP submits that if a complaint is given on 11/7/2023, the petitioner would not have rushed to this court filing a petition. Full stop. Even in terms of the provisions contained in the PPMP Act 2020, show cause notice is to be given to the alleged violator, objections are to be called for, explanation may be offered by such person, and the further action should also be taken only in accordance with law. So, for that purpose, sufficient time is necessary. Stop. Next para. Accepting the submission of the learned counsel for the respondent BBMP, the writ petition stands disposed of. Directing the second respondent Assistant Executive Engineer, HSR Subdivision, BBMP, to take note of the complaint dated 11/7/2023 at Annexure G given by the petitioner, issue notice to the third respondent, and thereafter proceed in accordance with law. Full stop. At any rate, the entire exercise shall be completed as expeditiously as possible and within a period of 3 months from the date of receipt of a copy of this order. Full stop. Yes. ಅವ್ರಿಗೆ ಆ ಪವರ್ಸ್ ಇದ್ರೆ ಅವ್ರ ಮಾಡ್ಬೋದು ಅದನ್ನು. Yes.
2 months ಮಾಡಿ.
No, no.
Otherwise you will complete the construction.
ಮಾಡಿದ್ರೆ ಹೊಡೆದಾಕ್ತಾರೆ ಬಿಡ್ರಿ, ನಿಮ್ಗೆ ಏನಾಗುತ್ತೆ?
By submission.
No, sir, that cannot be accepted.
At least 2 months.
If you say light and air, then we will say go to the civil court.
Not only later day.
Ashte. So therefore, if he has put up construction in violation of the sanction plan, they will have to take action in accordance with law. Let them take. Yes.
It's 2 months, man.
No, sir. No, no.
Number 4. Vijay Sukuria.
Huh? For what? Huh? What is the matter about? Direct respond number 3 to raise the compound around the cemetery. To an extent of 2 acres and 10 guntas. Specialties. Using the curved road in between cemetery and restore compound. Yeah, public interest litigation either. Huh? Then who is the petitioner? No, it is some individual. At the request of learned counsel for petitioner, release this matter on 24th of July.
Fine. And then you-
The 2.54 in Nepal, second stage Mysore. The respondent would have had allotted the price to one confirm. The confirm on that she paid the entire reservation, security, fees of sale again. And they issued the executed sale, conveyance deed in the paper. However, Malak, on the way to the workshop, she is misplaced. After Malak is only proceeding legally at the bottom of Madikama. After her death in 2015, he sold his right to the vendor of the petition. After the petitioner several representations have been made to the respondent, stating that any penalty or any applicable cess or tax would be paid on behalf of his vendors or predecessors.
What are you asking from them? How can you go and ask them to give a sale deed in your favor? You are not the allottee, but a sale deed is already executed in your favor.
Registered.
What do you mean?
Thereafter, the original sale deed was lost by him. It was never registered.
How can you go and ask for execution of a sale deed, sir?
On strength of the-
Learned counsel Shri T.P. Vivekananda is requested to take notice for the respondent. Learned counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on the learned counsel for the respondent.
Go to the secretary.
Serial number 6 appear for the petitioner. Serial number 6 appear for the petitioner. Say petition for seeking mandamus against the second respondent, my lord. To consider annexure D.
Then what is there in annexure D?
Annexure D is under the total
ನನ್ನ ಸ್ವಯಾರ್ಜಿತ ಸ್ವತ್ತಾದ ಮೈಸೂರು ತಾಲೂಕು ಸೋನ್ಸೋ ಗುಂಟೆ ಜಮೀನನ್ನು ಕೂಡ ಕಾನೂನು ಬಾಹಿರವಾಗಿ ನನಗೆ ಯಾವುದೇ ತಿಳುವಳಿಕೆ ಪತ್ರ ನೀಡದೆ RTCಯಲ್ಲಿ ಇಂಡೀಕರಿಸುವ ಬಗ್ಗೆ.
ಹೌದು, ಯಾಕೆಂದ್ರೆ ಟೋಟಲ್ 2 acre 18 guntas of land. As per annexure G itself, annexure G your lordship, 1 acre 18 guntas, 1 acre 18 guntas they acquired. Balance 1 acre ಅಲ್ಲಿ 24 ಗುಂಟೆ ನಾನು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದೇನೆ. ಈಗ ಅವರು ಅದನ್ನು ಮೂಡಾದ ಪ್ರಾಪರ್ಟಿ, ಬಟ್ annexure G ನೋಡಿ ಸ್ವಾಮಿ, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ kindly see annexure
STGP takes notice for response number 1 and 3. Learned counsel Shri T.P. Vivekananda is requested to take notice for response number 2. Learned counsel for petitioner is directed to serve 2 sets of copies of the petition along with annexures. Learned counsel for response number 2 and a copy in the learned HCG. Yes.
oblige.
Now, waiting.
Tax.
Tax is exempted. For Panchayat Raj, it is not done. Already we are seeking exemption.
Panchayat Raj.
Comes under the Panchayat Raj.
Have you challenged the rules?
But there are rules for the article 14 is not on parity. We are requesting the.
You are not aware, sir. There is a new rules framed. Yesterday there was a matter. Huh?
He is against the order.
Huh?
It is only like this part.
ಏನ್ರಿ ನೀವು ಅವ್ರಿಗೆ ರೂಲ್ಸ್ ಫ್ರೇಮ್ ಆಗಿರೋದು ಗೊತ್ತಿಲ್ಲ ಅವ್ರಿಗೆ. ಹೊಸದಾಗಿ ರೂಲ್ಸ್ ಫ್ರೇಮ್ ಆಗಿದೆ. We'll have to challenge it. They have challenged the rules.
Commitment to withdraw the petition.
Yes, yes. The grievance of the petitioner is that a demand notice is issued by the second respondent, Mudugere Grap Panchayat. Starting learned HCGP takes notice for respondent number 1. Learned counsel Sri M.S. Devraju, who is present in the court, takes notice for respondent number 2. Learned counsel for petitioner is directed to serve 2 sets of copies of the petition along with annexures on learned counsel for respondent number 2. Next paragraph. The grievance of the petitioner trust is that the second respondent Gram Panchayat is demanding payment of property tax from a trust, from the petitioner trust, which has established an educational institution on the property in question. Stop. Next paragraph. When it was brought to the notice of the learned counsel for petitioner that the state government through the Department of Gram Swaraj and Panchayat Raj Act, Panchayat Raj, has notified new set of rules governing the tax, collection, etc., learned counsel seeks leave of this court to withdraw the writ petition and raise a challenge to the rules. Full stop. Next paragraph. Placing the submission of the learned counsel for petitioner on record, the writ petition stands dismissed as withdrawn, while reserving liberty to the petitioner trust to raise a challenge to the new rules that are framed by the state government. Full stop.
Sridhar,
Pass over.
hello, PM.
Lord, I represent Lord the petitioner. Lord, petitioners are Lord tenants under Lord municipality, Lord commercial shop since 25 years. And Lord eviction notice was issued by the municipality as per Annexure A. Lord page 24. Lord, this eviction notice was challenged before the Honorable Court in a writ petition. Annexure B, my Lord, is the interim order granted by this Honorable Court. Lord, staying, Lord, the eviction. Lord, the relevant portion that could be at page 26.
You have been in occupation of the
Shops, Lord,
from
the
when?
municipality.
From when?
25 years long back, Lord, we are regular in payment of rent, and there is no dispute with respect to payment of rent. And Lord, the eviction notice issued was challenged before this Honorable Court. This Honorable Court granted a stay order, and subsequently writ petition came to be dismissed, allowed to treat that notice as Lord notice under the provisions of Transfer of Property Act, and I was supposed to show cause the notice.
Where is
That
that
was
order?
the order passed by this Honorable Court, a final order dated 30th March 2023. Lord, Annexure C is the order of this Honorable Court. Lord, the operative portion of the order, Lord, that could be at Lord, page 45. 45. Lord, the operative portion, Lord, reads, the petition is allowed in part. The notice dated 18/10/2022 at Annexure D is read down as notice under section 106 of the Transfer of Property Act, insofar as the petitioners who have not participated in the action. As regard the petitioner who have participated in the action and being declared as successful, they shall comply with the terms of the action. As regards to the petitioners who have participated in the action but not being successful, as also the petitioners who have not participated in the action proceeding, as aforesaid, Annexure D could be treated as notice under section 106 of the Transfer of Property Act. The concerned petitioner being required to reply to the said notice within 15 days from today, without waiting for a receipt of copy of this order. Insofar as the contention of the petitioners that interim order are being violated, petitioner are at liberty to take appropriate action if so advised. This is
Yes.
the final order passed by this Honorable Court. Lord,
Yes.
we have Lord, replied to the show cause notice. Annexure D 1 to 28 are our replacer. Lord, meanwhile, Lord, they have Lord, abruptly, Lord, illegally locked the shops. They are not allowing us to, Lord, go on with our business. Lord, as that, Lord, until unless this notice, treating as a notice under section 106 and an order request to be passed by the authority in accordance with law. Without doing that, Lord, they have locked the shops.
ಅದು ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ?
We are at liberty to take appropriate action if so advised. Lord, for that reason, we are before this Honorable Court, Lord, by way of it.
Not by way of a writ petition, sir. Not possible.
Lord, we have no alternative remedy, Lord, except this.
No. They have all the right to take over the property belonging to the municipality, which is a public property.
That is
Please
right,
see
Lord.
section 72.
That is right, Lord. But Lord, the writ petition says, and Lord, the eviction notice should be treated as a notice under section 106 of the TP Act.
1 and 2. Learned Counsel.
Lord, a livelihood of a poor person's, Lord, who are doing, Lord, petty business. These shops are not big shops. It is not heavy commercial transaction. They are doing, Lord, vegetable vending and all.
Sir, it is not permissible in law to grant lease for more than 5 years at a stretch.
Lord,
It
they
has to be put for
have
auction.
continued
You
as
have
Lord.
to ಬರೋದಿಲ್ಲ sir.
ಅಲ್ಲ ಅದ್ ಸರಿ ಅದು
It's a
5
public
ವರ್ಷಕ್ಕೊಮ್ಮೆ
property.
ಮಾಡ್ಬೇಕು,
Please understand.
ಇದೆ, ಎಲ್ಲ ಇದೆ.
ಮತ್ತೆ?
25 ವರ್ಷ ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಕ್ ಬರೋದಿಲ್ಲ, ಅದೇ ತಪ್ಪಾಗಿರೋದು. ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಅವ್ರು ತಪ್ಪು ಮಾಡ್ಬಿಟ್ಟು ನಮ್ಮನ್ನ ಪನಿಷ್ಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಏನ್ ಪನಿಷ್ಮೆಂಟ್ ಆಗುತ್ತೆ? They have taken in action in accordance with law.
ಇಲ್ಲ, ಅವ್ರನ್ನ ಯಾರು ನಮ್ ಪ್ರಾಪರ್ಟಿನ ಆಕ್ಷನ್ ಅಲ್ಲಿ ಪರ್ಚೇಸ್ ಮಾಡಿಲ್ಲ. ಆಕ್ಷನ್ ಅಲ್ಲಿ ಆಗಿರೋದು ಬೇರೆ ಪ್ರಾಪರ್ಟಿ. ಅವರೆಲ್ಲ ಅವ್ರು ಸೆಟ್ಲ್ ಆಗಿದ್ದಾರೆ ಈಗಾಗಲೇ.
Has to be put for auction. You will not be
ನಮ್ದು ಅಲ್ಲಿವರೆಗೂ ಅಟ್ ಲೀಸ್ಟ್ ಬಿಸ್ನೆಸ್ ಮಾಡಕ್ ಅವಕಾಶ ಮಾಡಿಕೊಟ್ರೆ ಆಕ್ಷನ್ ಆಗಿ ಬೇರೆಯವ್ರಿಗೆ ಇದು ಅಲಾಟ್ ಬಿಟ್ಬಿಡ್ತೀವಿ.
CMC ಹುಣಸೂರು. Learned Counsel Srimati Geeta Devi Papanna is requested to take notice for respond number 3 CMC, Hunsur. Learned Counsel for petitioner is directed to serve 2 sets of copies of the petition along with annexures on Learned Counsel for respond number 3 and a copy on the learned HCGP. Full stop. Release this matter on 26th of July.
ಸ್ವಾಮಿ ಅಟ್ ಲೀಸ್ಟ್ ಅಲ್ಲಿವರೆಗಾದ್ರೂ ಬಿಸ್ನೆಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಮಾಡಿಕೊಟ್ರು. ಏನಿಲ್ಲ, ನಮ್ಮ ಮೆಟೀರಿಯಲ್ ಎಲ್ಲ ಅಂಗಡಿ ಒಳಗಡೆ ಇದೆ.
You come and make a statement on the next date of hearing that you want to remove it. I'll permit you and let them.
Today itself, Lord, I will undertake.
There is no one here.
ಅಲ್ಲ
Let us
ಅವ್ರು
see.
ಬರೀ ಲಾಕ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅದ್ ಬಿಟ್ಟರೆ ಮಿಕ್ಕಿದ್ ಏನು ಆಕ್ಷನ್ ಆಗಿಲ್ಲ.
Serial number 10.
Yes,
June 30th. Regard to the unified bylaws, the primary agriculture trade.
same orders. I think WP number 13460 of 2023. Dated 30th of June.
Very good. Action to the most. Being postponed the examination of the eviction. First, the returning of the vacancy arose in the post of president upon resignation on 17/4/2023. The first returning officer was appointed on 29/5/2023.
What is copy? This
Last occasion, we got your logic to this that after the first returning officer was appointed on 29/5/2023. On 8/6/2023, the returning officer said that I am busy, I am not in a position to conduct the election to appoint somebody else. It is at that time he came before resolvable court at the first instance, that is WP number 13009 of 2023. Now, after we filed the petition, the lordship asked him to take the government advocate to take inspection. They appointed the second returning officer. Second returning officer after is appointed, he fixes the meeting on 6/7/2023. Because the elections were conducted on 8/9/2019 to the board. A dispute under section 70 is entertained on 5th at 1 o'clock. Ex parte interim order is granted saying that certain directors should not participate in the elections. 6th is the meeting. 6th, the meeting does not take place because there is no quorum. He disqualifies 2 of the persons not to attend the meeting. Somehow they wanted to manipulate with the democratic process. That's the official respondent themselves. 6th, when the meeting does not take place. 7th, the complaint, the dispute is withdrawn. Not that the dispute, the time period within which the election could be challenged is 30 days. He entertains this at an election of 2009 dispute. He entertains in year 2023 and grants an interim order that 4 directors should not participate in the elections. Then that is dispute is withdrawn. Now again it is rescheduled on 24th. But I am only requesting this mischief may not happen because I am in a position to demonstrate. Not once. Thrice this mischief has happened. Some of this state machinery is being misused. We do not know the reason. They somehow want to manipulate with this democratic process. Thrice they have done it. Once the returning officer, he is ensured that he does not conduct the election. Second returning officer, once he is appointed, he fixes the date. Thereafter, the state intervenes and says that under section 70, let directors do not participate in the meeting. Now it is scheduled on 24th. Let it be conducted without any hazards. They will do some other mistake. That's the whole problem with which we are facing.
learned AGA takes notice for learned counsel Sri TL Kiran Kumar is requested to take notice for respondent number 2.
So only sought for a relief that let them not disqualify me from voting at this juncture after 24/7, up to 24/7. Let the elections take place. If eventually if they find that there is some ground for disqualification, I have no difficulty. I have not said not to disqualify. I withdraw myself, not that they should not disqualify. I will not stand on that because there is no intent disqualification. Let them not prevent any of them from casting their votes. Somehow they are playing this system. State government machinery is playing this system.
Issue emergent notice to respond number 7. Learned counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on learned counsel for respond number 2 and a copy on the learned AGA. Full stop. Next para. Learned senior counsel Sri D.R. Ravi Shankar, appearing for the petitioners, submits that earlier the petitioners had filed WP number 13009 of 2023, complaining that although a returning officer was appointed to conduct the elections to the post of president of the seventh respondent society. Nevertheless, the said returning officer had expressed his inability to conduct the elections and requested for appointment of any other person. Stop. It is submitted that this court, by an interim order dated 23/6/2023, had directed the learned AGA to secure instructions in the matter of conducting elections to the post of president. Stop. Thereafter, one another person was appointed as the returning officer, and he had scheduled the meeting to be held on 6/7/2023. Stop. For some reason, the meeting was not held, the election was not held as scheduled. Full stop. On the other hand, it is submitted that at the instance of a few other members of the society who had raised a dispute by filing a petition under section 70 of the Karnataka Cooperative Societies Act, by way of an interim order, who is that officer?
Fourth respondent here, fifth respondent here.
The fifth respondent, Assistant Registrar of Cooperative Societies, Mandya Division, is said to have disqualified or prevented some petitioners number 2 and 3 from participating in the elections. Full stop. However, after the elections were rescheduled to be held on 24/7/2023, the dispute filed under section 70 was withdrawn. Stop. Learned Senior Counsel would therefore submit that all efforts are being made to derail the democratic process, and the respondent officials are also intervening to facilitate such curtailment of the democratic rights of some of the petitioners herein. Full stop. Nevertheless, Learned Senior Counsel would submit that it would suffice if the elections scheduled to be held on 24th of July is conducted in accordance with law. We'll stop. Next para. Learned AGA is directed to give necessary instructions to the sixth respondent returning officer to go ahead with the elections that are scheduled to be held on 24th of July. Full stop. Release this matter on 25th. We'll have 25th of July. Then released WP number 13009 of 2023 along with this matter. ಇವತ್ತು ಬಂದಿದ್ಯಾ
The subsequent events
ಹಂಗಾರ ತೆಗ್ದ್ಬಿಡಿ, ಲಾಸ್ಟ್ ತೆಗ್ದ್ಬಿಡಿ. ಸೀರಿಯಲ್ ನಂಬರು ಇಲ್ಲೇ ಇದೆಯಾ? ಅದು ಸೆಪರೇಟ್ ಆಗಿ ಇದು ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರಲ್ಲಿ WP number 130009 of 2023. ಅದರಲ್ಲಿ
Record my statement. We are the subsequent events, the second petition will not survive for losses.
ಅಲ್ಲಿ ಅದರಲ್ಲಿ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ಹೇಳಿದ್ವಲ್ಲ ದಿಸ್ WP 13009 ವಾಸ್ ಫೈಲ್ಡ್ ಅನ್ಬಿಟ್ಟು ಅದೆಲ್ಲ ಬರ್ಲಿ ಸೇಮ್ ಬಿಕಾಸ್ ಇಟ್ ಇಸ್ ಸೇಮ್ ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್ ಅದೇ ಬರ್ಲಿ ನಾ ಆಮೇಲೆ ಇನ್ನೊಂದ್ ತರ ಹಾಕ್ತೀನಿ. In view of the subsequent developments, learned senior counsel appearing for the petitioners would submit that the prayer made in the writ petition has become infructuous and therefore the writ petition may be permitted to be withdrawn. Full stop. Next para. Accordingly, the writ petition stands dismissed as withdrawn.
Section F is the impugned order of notes. Petitioner's grandfather purchased the property in the year 1944 as per annexure A sale deed below. Thereafter, we are enjoying the properties. All of a sudden, my lord, the kata of the properties was changed in the name of fourth respondent on the ground that, my lord, sir, he is in possession of the property. That's what they say, my lord. I am in possession of the property and other things. As
You had filed a petition under section 269.
the executive officer, my lord, sir. That has been returned
With what prayer?
with the prayer to change the kata in my name on the basis of the registered sale deed. And fourth respondent is
That
not
up-
having any document.
That application should have been given to the PDO.
Yes, he filed a report stating that, my lord.
That application was required to be submitted before the PDO.
I
If the
submitted.
PDO had passed any order,
He
only
filed a
then
report stating that
you did not file an application before the PDO.
I
You
filed
directly,
filed as per annexure email. At ink page 12, type the copy as ink page 13.
huh,
I filed that application.
huh.
Thereafter, he filed, issued a notice on 29/9/2022 to the party, my lords, including fourth respondent. And thereafter, he files a report stating that, my lord,
Files a report where?
report to the Tahsildar, stating that, my lord,
Why should he file a report to Tahsildar?
he files a report. My lord.
Huh?
He files a report, spot inspection, he conducts a spot inspection,
Huh.
and he files a report,
Where is that?
annexure D, my lord. In page 17 type. ಅದರಲ್ಲಿ ಫೋರ್ತ್ ಪ್ಯಾರಾಮೀಟರ್ ಅರ್ಜಿದಾರರು ಕಂಪಲಾಪುರ ಗ್ರಾಮದ ನಿವಾಸಿಯಾಗಿದ್ದು 44ರ ಕ್ರಯಪತ್ರದ ಆಧಾರದ ಮೇರೆಗೆ ನಿವೇಶನದ ಖಾತೆ ಮಾಡಿಕೊಂಡು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ಹಾಗೂ ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಆಸ್ತಿಗೆ ಇತ್ತೀಚಿನ ಇಸಿ ಲಗತ್ತಿಸಿರುವುದಿಲ್ಲ.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದೀರಾ ನೀವು?
ಇನ್ ಪೇಜ್
17 ಅಲ್ಲಿ
ಫೋರ್ತ್ ಪ್ಯಾರಾ. ಅರ್ಜಿದಾರರು ಕಂಪಲಾಪುರ ಗ್ರಾಮದ
ಹಾ
ನಿವಾಸಿಯಾಗಿ ಇಂದು 44ರ ಕ್ರಯಪತ್ರದ ಆಧಾರದ ಮೇಲೆ ನಿವೇಶನದ ಖಾತೆ ಮಾಡಿಕೊಂಡು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ಹಾಗೂ ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಆಸ್ತಿಗೆ ಇತ್ತೀಚಿನ ಇಸಿಯನ್ನು ಲಗತ್ತಿಸಿರುವುದಿಲ್ಲ ಹಾಗೂ ಕ್ರಯಪತ್ರದ ಪ್ರಕಾರ ಇರುವ ಆಸ್ತಿ.
How is it that you are asking for transfer of kata on the basis of a sale deed dated of year 1944 now?
ಅಲ್ಲ, ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್ ಹೆಸರಲ್ಲಿ ಇದ್ದಿದ್ದು,
ಹಾ
ಆಮೇಲೆ ಫಾದರ್, ಆಮೇಲೆ ಈಗ ಇವ್ರ ಹೆಸರಿಗೆ ಬರಬೇಕಾಗಿದೆ. ಆಫ್ಟರ್
the previous kata was standing in the name of your father.
now it is standing in the name of fourth. Now presently
From when?
it is from 2016 when
2016.
yes, all of a sudden on the ground of possession kata has been taken.
It's a vacant land, is it?
It is my property.
It's a vacant land.
Yes,
So from 2016, the kata is standing in the name of the fourth respondent.
thereafter I filed this application and he files a report stating that possession is with him and on the basis of the statement by the some of the villagers, and he files a report and close the matter. Thereafter I filed appeal before the executive officer, before the Piriyapatna, my lords, under section 269 of the Act. my
Yes.
lords. And
He says it's in the nature of a civil dispute.
he
Go
says
before
that-
the civil court.
Yes, he says that he returns the file, my lord. He
Correct.
has to pass orders on my appeal, my lords. He cannot issue endorsement, even if he passes that order. He has to fight the reason, and he has to give the opportunity to the other side, and he has to pass order.
ಏನೇ ಮಾಡಿದ್ರು ultimately that will be the end result. He will not be able to decide the title.
Allah, I am not saying that, my lord. When he
Some other person has got his name entered in the Kata register
Yes.
from the year 2016, and you have not questioned it. For the first
I-
time, you are doing it now in the year 2022.
I am not aware of that.
Therefore, he is saying it's a civil dispute. Please go before the civil court, get a declaration.
Correct, my lord. At least he has to produce one document.
It is
Stating
not for him.
that-
No, sir.
He is the owner of the property, my lord.
Revenue authorities are not permitted to enter into a question of disputed title.
Change the kata.
Yes, there is an objection that was done in the year 2016, sir.
No notice issued, my lord.
Therefore, there is a dispute. The property is now standing in the name of another person,
Yes,
isn't it?
yes.
He claims that it is a property belonging to him. There is a dispute of title that cannot be decided by the authorities. That is the law.
Correct, my lord.
So therefore,
Change the
even
kata.
if he has not given all these elaborate reasons, he has simply said, go before the civil court. Ultimately, you have to go before the civil court. We are not going to permit the executive officer of the Taluk Panchayat to decide this issue. You have to go before the civil court.
Now, may I submit this one, my lord? Since 1944.
Sir,
Up to
all that
2016,
cannot be decided by them.
registered
It
document.
cannot be decided by them. That is the law.
At least he has to place one document.
Our document placed madrunu, it will not be within the power of the executive officer to go into that aspect and decide the title. He has no such power.
Even on the ground of principles of natural justice also, my lord, to change the kata.
ಅದು ಆಗೋಗಿದೆ ಸರ್ 2016 ಅಲ್ಲಿ. There is a dispute now. That is why he is saying you please go to the civil court. ಬರ್ಕೊಳ್ಳಿ.
One submission, my lord, if that is the case, my lord, sir. If the kata is changed by making such type of orders, my lord. Thereafter, my lord, sir, the person who is owning the title on the basis of the document.
Correct,
He
sir.
has to go to the civil court, my lord, say, these officers will change the kata abruptly, my lords. And we have to go to the civil court, my lord, sir.
Yes.
Now, if there is anything to show that he is the owner, then it's okay, my lords. But here, he himself stated that on the basis of the statement made by some of the villagers, my lord.
Sir, that was done. That action was taken way well, long back in the year 2016.
Without issuing notice.
ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? You have also remained quiet.
Even now, I am in position, my lord, sir.
You have not paid the taxes.
I paid.
How could you pay when the kata is made out in the name of that other person?
Tax ಯಾರು ಕೊಟ್ಟು
2016.
ಯಾರು
ಅದೇ ಅವ್ರ ಹೆಸರಲ್ಲಿ ತಗೊಂಡಿರ್ತಾರೆ.
ಅಲ್ಲ ತಗೊಂಡಿರ್ತಾರೆ, ಬಟ್ ನಾನು ಕಟ್ಟಿದ್ದೀನಿ.
ಅದೇ
ಪಕ್ಕದಲ್ಲೇ ಇದೆ.
ಕಟ್ಟಿದ್ರು ಅವನ ಹೆಸರಲ್ಲಿ ಹೋಗಿರುತ್ತೆ.
ಅಲ್ಲ ಹೋಗಿರ್ತದೆ.
ಏನ್ ಮಾಡಕ್?
At least the enquiry will have to be conducted.
No,
That's
sir.
what my-
This is the law settled by this court. That disputed questions of title cannot be gone into by revenue authorities.
Correct.
It is the civil court alone which has to decide it.
But insofar as in this case, my lord, without the title documents.
ಅದೇ ಸರ್, ನೀವು ತಗೊಂಡೋಗಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಟ್ರುನು, ಅವ್ರ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ತಂದು ಇಟ್ರುನು, he will not be able to decide that issue. Because it is a question of deciding the title. That power does not vest with the authorities.
But they
petitioner,
on the ground that
learned,
he is not.
HCGP takes notice for respondent number 1. Notice to the other respondents is not necessary for the following reason. Next paragraph. The petitioner is aggrieved of the impugned endorsement dated 13/12/2022 at annexure F issued by the second respondent, executive officer of the Taluk Panchayat, Piriyapatna, declining to entertain a petition under section 269 of the Karnataka Gram Swaraj and Panchayat Raj Act of 1993. Stop. Next para. The petitioner appears to have approached the third respondent, Panchayat Development Officer, Kamalapura Gram Panchayat, seeking transfer of kata in respect of the land in question from the name of his father. Huh?
Father's.
You want it in your father's name.
ಆದ್ಮೇಲೆ ನನ್ನ ಹೆಸರು.
How is that your father didn't get it transferred in his name?
ಅಲ್ಲ ಚೇಂಜ್ ಮಾಡಿರೋದು ಫಾದರ್ ಹೆಸರಿಂದಾನೇ ಚೇಂಜ್ ಮಾಡಿ. ನನ್ನ ಫಾದರ್ ಹೆಸರಲ್ಲೇ ಇತ್ತು, ನಾನು ಚೇಂಜ್ ಮಾಡಿದ್ರು. ಅವ್ರು ಪರ್ಚೇಸ್ ಮಾಡಿ.
Where is the kata which shows your father's name was entered?
Not produced.
Question number 3 to the board. Kamalapura Gram Panchayat taking transfer of kata in respect of land in question from the name of his father.
To the name of his father. On the strength of a registered sale of the year 1944. Full stop. The Panchayat Development Officer appears to have ಅವರು ಒಂದು ಕೊಟ್ಟಿದಾರಲ್ಲ ನಿಮ್ಗೆ ತಿಳುವಳಿಕೆ
ಅಲ್ಲ ನೋಟಿಸ್.
ಹ?
ನೋಟಿಸ್ 11:30ಕ್ಕೆ 1/10/22 ಸ್ಥಳ ತನಿಖೆ ಮಾಡ್ತೀವಿ. ಆ ಬೇಸಿಸ್ ಅಲ್ಲಿ ರಿಪೋರ್ಟ್ ಫೈಲ್ ಮಾಡಿ
appears to have issued a notice on 29/9/2022 to the petitioner to appear at the spot for a spot inspection. Stop. Thereafter, a report is said to have been submitted to the Tahsildar, stating
fourth respondent and one more Shivalinge Gowda is in position.
that the fourth respondent and one Shri Shivalinge Gowda are in possession of the property for more than 55 to 60 years. And it would not be possible to enter the name of the petitioner's father in the assessment list of the Gram Panchayat. Stop. Thereafter, the petitioner filed a petition under section 269 of the Act before the executive officer of the Taluk Panchayat. Full stop. The Taluk Panchayat, the executive officer of the Taluk Panchayat issued the impugned endorsement dated 13/12/2022, declining to entertain the petition and directed the petitioner to approach a competent civil court, since the dispute is in the nature of a civil dispute. Stop. Next para. Although learned counsel for the petitioner seeks to submit that no plausible reasons are found for declining to entertain the petition filed under section 269, this court is of the considered opinion that the reasoning of the executive officer of the Taluk Panchayat that the dispute brought before the executive officer is in the nature of a civil dispute, is sufficient to hold that no infirmity can be found in the impugned endorsement. Stop. Time and again, this court has held that disputed questions of title cannot be decided by revenue authorities, comma, which would also hold good to the officers manning the local bodies. So, in that way of the matter, comma, the petitioner is required to approach a competent civil court and get a declaration of title. Full stop. As and when a declaration is obtained by the petitioner, comma, he would be entitled to have his name entered in the records of the respondent Gram Panchayat. Full stop. Ordered accordingly. For the reason stated above, the writ petition stands dismissed.
Petitions number 13, Manjunatha H.A.
So this with respect to the license agreement paid 2/11/21. Now, seeking the agreement as an arbitration clause and
ಕನಿಸಿ ಯಾವಾಗ ಸರ್ವ್ ಆಗಿದೆ ನೋಡ್ರಿ, ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾವಾಗ ಸರ್ವ್ ಆಗಿದೆ? 25/4.
party the child.
So, notice is said to have been served on the respondent on 25/4/2023, comma, there has been no appearance. Full stop. Nevertheless, release this matter on 26th of July.
R2G.
Election is scheduled to be held on 22nd of this month. But the office of the term of the office ends on 22nd of August. It has been scheduled to be held prematurely so as to exclude the petitioners from the voter list.
Huh?
Has been scheduled to be held prematurely so as to exclude the petitioners from the voter list.
List of disqualified members is published, is there?
That has already been published.
Illi.
I've not put up the list, but there's a notification at Annexure M. The direction has been given to hold the elections here. Calendar of events is at Annexure T, Annexure M 108.
Annexure T na.
Annexure T is the calendar.
Annexure? Page number?
110.
Annexure N na. ದಿನಾಂಕ 18/3/2020. ಹಾ. ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ರೆ ನನ್ಗೆ ಐ ಆಮ್ ನಾಟ್ ಏಬಲ್ ಟು ಗೆಟ್ ಇಟ್. ಹಾ. ಹ್ಮ್. 26/5. That is annexure M. ಅಲ್ಲ ನಮ್ದ್ರಲ್ಲಿ annexure M ಇದೆ ಅದು. ಏನ್ರಿ?
26/5/20.
Page 108 annexure M. Annexure N is a
110 is Annexure
a
M.
resolution. ಅದೇನು ವ್ಯತ್ಯಾಸ ಆಗಿದೆ?
She's saying is right, but even I'm unable to follow as which paragraph she is reading.
ಅದು annexure M ನನ್ನಲ್ಲಿ. Page 108 annexure M. You are reading a communication. That is annexure M. ಆಯ್ತು ಓದಿ.
ಎಲ್ಲ ಇದೆ.
You are all defaulters. Then why are you challenging this one then?
We enrolled as members sometime in the month of July end and first week of August last year, Your Lordship. One version to get eligibility, we need to be members for at least 1 year. This has been prematurely scheduled so that people such as petitioners similarly placed persons are excluded from the voter list. The term of the office ends on 22nd August next month, but the election has been held 1 month prematurely. You ought to have held the election after 22nd of August next month. Next month. Your Lordship.
After Allah. It cannot be after. It has to be before only.
September
No. Which is the provision?
Section 27O. The cooperative society to convene a general meeting of its members once in a year before 25th day of September for the purpose of
ಸ್ವಲ್ಪ ಇರಿ ಸ್ವಾಮಿ, ನಮಗೂ ಪ್ರಾವಿಷನ್ ತಗಿಲಿ. ಲೆಟ್ ಮಿ ಸಿ.
27O.
Seven.
27O. The cooperative society shall convene a general.
ಯಾವ್ದು 27O? ಯಾವ್ದು 27O?
Cooperative society is that 27O.
27O ಅಂತ ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ. 27O ರಿಗಾರ್ಡಿಂಗ್ annual general meeting. O ಅಲ್ಲಿ consideration of any other matter which may be brought forward in accordance with the bylaws.
What I am saying is that until 25th they have time.
Which is the provision, sir, as to when the next election should be held? ಯಾವ್ದಮ್ಮ?
39A.
Conduct of elections. Provided that the cooperative election authority may start the preparatory work for the preparation of the electoral rules for and the conduct of the elections during the last 6 months prior to the expiry of the term of the office. So, Pradilla.
One submission. There is one candidate by name T.R. Nagaraj. He was enrolled on 25th of May, 23rd of May this year. He's been given membership and he's been allowed to vote. For the reason that he happens to be the relative of the president. And also there is an inquiry going on as against the.
They have published a voters list.
That has been published.
When was it published?
On 6th of this month.
6th.
6th of this.
So
20 days, 21 days prior they have published the voting list.
Has
not been complied. ದಿನದೊಳಗಾಗಿ ಮಾಡ್ಬೇಕಾಗಿದೆ. ಮುಂಚಿತವಾಗಿ.
Where is that list? Where is that list?
Not very the entire list. And I don't give it the.
ಆಗೋದಿಲ್ಲ. This prayer cannot be granted because once the calendar of events are announced, no court can pass any order causing any interference in the process of election.
Case where this election of duty on part of the members, even governing members are.
If you are already a member and a list of disqualified members are published, we have held that that kind of a disqualification without issuance of individual notice cannot be sustained, and therefore we permitted them to participate in the elections. But you are not even a member who would become eligible to vote. So you will not stand on the same footing as them, and there is no list of disqualified members to show that your name is included there. ಆಗೋದಿಲ್ಲ.
Pass over, I'll withdraw the petition and make submission and I'll withdraw the petition.
Pass over. Yes. Certified copy of Annexure G. G. Annexure G. Huh? ಅನಧಿಕೃತವಾಗಿ ನಿವೇಶನವನ್ನು ಮಾರಾಟ ಮಾಡಿರುವ ಬಗ್ಗೆ what this is your letter, is it? Annexure G.
They are planning.
Issue a writ of mandamus quashing the complaint filed by responsible. Yes, office objection is overruled. ಹೇಳಿ. ಹೇಳಿ, please say. I have overruled the office objections. ಏನಮ್ಮ ಇದಕ್ಕೊಂದ್ ದಿವಸ ಅದಕ್ಕೊಂದ್ ದಿವಸ ಏನು, ವಾಟ್ ಇಸ್ ದಿಸ್? If there is any urgency, you can make your submissions. Otherwise, we'll simply issue notice. ಅಷ್ಟೇ. What is your interim prayer? Pending disposal of the petition, you please to stay the operation of the impugned order of the year 2013. ಹೆಂಗ್ ಮಾಡಕ್ ಬರುತ್ತೆ? See your interim prayer. 10451. ಹೌದು. See what is your interim prayer. Main prayer ಅದೇನೆ. You are questioning an order of the year 2013 and you want that to be stayed now. Not possible. Okay. Learned HCGP takes notice for response number 1 and 9. ಇಶ್ಯೂ ಇವ್ರಿಗೆ ಬೈಯಪ್ಪ ಯಾರ ಹತ್ರ ಆಗ್ತಾರೆ learned counsel Sri Yogesh D Nayak is requested to take notice for respond number 2. Stop. Learned counsel for the issue notice to response number 3 to 8. Your HCDP for 1, 9 and 10. Learned counsel for petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on learned counsel for respond number 2 and a copy on the learned HCDP. Yes.
Package, Isami, from
Learned counsel for the petitioner has filed a memo dated 18/7/2023 stating that a dispute between the parties is presently pending before the civil court and the petitioner wishes to proceed with the matter before the civil court. So therefore, the petitioner may be permitted to withdraw this CMP. Full stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the CMP stands dismissed as withdrawn.
Banking permission will be not authorized. But except the demand notices, they can reconsider.
no advertisement funds.
Huh? Ian, what does it matter about?
Advertisement tax.
Ah,
From 2014 onwards, they had given us demand notices. Show cause whether we can be taxed. Now there are no wordings, they cannot be wordings. We cannot get permission or not.
ah.
The only thing is not whether we have to pay that tax during that period of removal is the only question.
Already raised.
Already raised.
Demand is already raised.
It's raised not by show cause notice.
Yes.
So we may have to be given opportunity to answer it. But any date can be fixed by them so that we can appear with the content.
IPS will not appear to the petition.
Hmm.
So not even voting, it won't be a shop board with the.
Angara, that is covered in the other
Other
matter. ಅದು, advertisement shops putting the name boards. So same order. ಅದು ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಕೊಡಿ. ನಿಮ್ದು ಯಾವ್ದು ರಿಟ್ ಪಿಟಿಷನ್? 17.1. 17.1 ನಲ್ಲಿ WP ನಂಬರ್ 51275 of 2015. ಅದನ್ನ dispose of in the same terms of ಯಾವ್ದಾದ್ರು ರಿಟ್ ಪಿಟಿಷನ್. ಆಮೇಲೆ ಅವ್ರು ಕೊಡಿ. Yes, yours will be disposed of in terms of that. And your petition will be allowed and the demand notice will be set aside.
Demand notices we may be given.
Yes, what do you say?
17.2.
Alright, it's all right. Commonly, he is appearing for all the petitioners and you may make submissions on behalf of the BBMP. The submission is that these are all old demands raised and they may be permitted to have their say before the authority. Let them hear the objections and thereafter pass order. ಏನ್ ಬೇಕಾಗಿಲ್ಲ, ನಾಟ್ ನೆಸೆಸರಿ. ಅವಾಗ ಆ ಟೈಮಲ್ಲಿ ಮೋಸ್ಟ್ಲಿ ವೆನ್ ದಿ ರಿಟ್ ಪಿಟಿಷನ್ಸ್ ವರ್ ಫೈಲ್ಡ್ ಅವಾಗ ಹಾಕಿದ್ರು ಅಂತ ಕಾಣುತ್ತೆ. ನೌ ದೇರ್ ಇಸ್ ನೋ ಹೋರ್ಡಿಂಗ್. Workplace.
17.2.
ನಿಮ್ದು ಯಾರ ನಿಮ್ದು ನಿಮ್ಮ
ಎಲ್ಲಾನು ಹಾಗೇನೆ ಚೆಕ್ ಮಾಡಿ.
ಅದೇ ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ ಯಾವ್ಯಾವ್ದು ಇದೆಯೋ ಎವ್ರಿಥಿಂಗ್ ವಿಲ್ ಬಿ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಆನ್ ದಿ ಸೇಮ್ ಲೈನ್ಸ್. ವಾಟ್ ಅಬೌಟ್ ಮಿಸ್ಟರ್ ವಿವೇಕ್ ಹೊಳ್ಳ?
Vivek Kola in
4, 5 and 6
it's similar to.
same. Then 50 17 point. Yes, Sanjay Nair. Sanjay Nair. That is what, sir. That is the submission made.
Submission is there. And submitted by decline, but without considering, without weighing my side, they have passed these orders.
All right. Same benefits. Same benefit will be given to you.
Even orders also will be passed.
We will say if any order has been passed, that is taken as set aside, and opportunity shall be given. There are other petitioners also. Same. So we'll pass orders on the same lines in all these matters. ಅಕಸ್ಮಾತ್ ಯಾರು ಆಮೇಲೆ ಬಂದು ಇಲ್ಲ ನಮ್ದು ಆತರ ಎಲ್ಲ ಬೇಡ ಬೇರೆ ಅಂದ್ರೆ ಯು ಜಸ್ಟ್ ಇನ್ಫಾರ್ಮ್, ಅದೊಂದು ಇಟ್ ವಿಲ್ ಬಿ ಡಿಲೀಟೆಡ್ ಫ್ರಮ್ ದಟ್ ಲಿಸ್ಟ್. ವಿ ವಿಲ್ ಸಿ ವಾಟ್ ಶುಡ್ ಬಿ ಡನ್. ಅಲ್ಲ ಬೇರೆ ಯಾರು ಇವಾಗ ಬೇರೆ ಕೌನ್ಸಿಲ್ಸ್ ಇದಾರಲ್ಲ, ಅಲ್ಲ ಅವ್ರೇನಾದ್ರು ಬಂದು ಇಲ್ಲ ನಮ್ದು ಆತರದ್ದೆಲ್ಲ ನಮ್ದು ಬೇರೆ ಅಂತಂದ್ರೆ I am saying this order will not apply in that case. That will be kept out. Okay. Since the grievance of all these writ petitioners directed against the respondent BBMP is common, these writ petitions are clubbed, heard together and disposed of by this common order. Please stop. Next para. Learned Counsel Sri V.V. Shivkumar, appearing for many of the writ petitioners herein, submits that in all these writ petitions, demand have been raised by the concerned revenue officer in respect of the hoardings, bar advertisements, bar display boards for the years 2015, 16, 17. Or even prior to that. Stop. Learned Counsel submits that subsequently, by way of a policy decision, the BBMP has stopped granting permissions for putting up advertisement boards, hoardings, etc. Stop. The Learned Counsel would therefore submit that since these are all old claims and in all these matters demands have been raised and orders have been passed in some cases without hearing the petitioners, the Learned Counsel would submit that the matters may be remitted back to the concerned assistant revenue officer to afford an opportunity of hearing to the petitioners and thereafter pass orders in accordance with law. Full stop. Next para. Accepting the other learned counsels appearing for the petitioners also support the submission of the learned counsel. Full stop. Next para.
Have been exempted. So these are,
All that you'll have to go and submit before them, sir. We are not we have not gone anything on the matter, merits of the matter. Objections can be filed. You will have to be permitted to have offer your explanation. Thereafter, we can pass order. Accepting the submission of the learned counsels for the writ petitioners, comma. These writ petitions are disposed of in the following terms. 1. Wherever orders have been passed by the assistant revenue officer or the competent authority, comma, the same are set aside. Full stop. Let's go. In respect of all other matters where challenge have been raised to the demand notices, comma, the writ petitions stand disposed of. Full stop. Next. In all these matters, the matters stand remanded back to the respective assistant revenue officers or competent officers who have issued demand notices or orders for reconsideration afresh. Stop. Opportunity shall be granted to the writ petitioners to file written objections, and thereafter the parties shall be heard and orders shall be passed in accordance with law. Full stop. Ordered accordingly. No, not again. Again, it is not possible. This Barkal Inand. The petitioners herein are permitted to file written objections before the respondent, the respective assistant revenue officers or competent officers who have issued the demand notices or orders within a period of 15 days from the date of receipt of a copy of this order. Full stop. Thereafter, the concerned officer shall afford an opportunity of hearing to the petitioners and thereafter proceed to pass orders in accordance with law. I 4 weeks. In all matters, you please show the name of the learned counsel.
appearing for petition. The case may not bear. The petitioner is a society. The municipal committee may not allotted a civic committee society. They received the sale consideration for the entire area. While executing the sale, a lesser area was given to us. despite their reaching with the full constitution. Father, we filed the requisition, no, my lord, other side.
Yaru, who allotted the CA site?
Sitting town municipal council. Panchayat, local panchayat. No, my lord. they
CA
filed-
sites,
They filed a memo. They agreed to allotted the remaining area to us. And the memo and the certain documents are also included along with my lord one letter of undertaking. Based on this and according to sufficient evidence will be disposed of. Already been given, Mr. Harmon, along with the. memo. They have already given everything.
ಮುಚ್ಚಳಿಕೆ ಇವ್ರದ್ದು, ನಿಮ್ದೇ ಮುಚ್ಚಳಿಕೆ, ಅವ್ರದ್ದಲ್ಲ. ಅವ್ರು ಹಾಕಿರೋ ಮೆಮೋ ಅಲ್ಲಿ ನಿಮ್ಮ ಮುಚ್ಚಳಿಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಏನಂತ ಹೇಳಿದ್ದಾರೆ ಅದರಲ್ಲಿ?
ಅವ್ರು memo ಆಗಿದೆ.
ಬಂದಿದೆ, ದೇ ಹ್ಯಾವ್ ರಿಸೀವ್ಡ್ ಅಂತ ಹೇಳಿದ್ರು.
That's what I am. Yes, sketch is also annexed to show what area was allotted.
ಈ
Memo may kindly be recorded. Recording their sufficient blood could be disposed.
the petitioners are before this court aggrieved of the fact that there is deficiency of (414 square meters of land in the civic community site that was granted by the respondent Pasdurga Town Municipal Council, although and it is not in accordance with the schedule provided in the sale deed dated 3/7/2017. Full stop. Next para. However, a memo dated 30/5/2023 has been filed at the hands of the third respondent, Chief Officer of the Town Municipal Council, Hosudurga, stating that subsequently the deficient area has been given to the possession of the petitioner society. So, in this regard, an affidavit in the form of an undertaking is given by the grievance of the petitioner society does not survive for consideration. Full stop. Next para. In
It is also a
learned senior counsel Sri M.R. Rajgopal, appearing for the petitioner society, would submit that a sketch in the form of annexure R1 has been appended to the affidavit for undertaking and the memo filed by the third respondent, Chief Officer, and the same should be taken note of. Stop. Next para. In view of the subsequent developments and in view of the fact that the deficient land has been put in possession of the petitioner society, and the petitioner society has filed an affidavit showing its satisfaction of the subsequent action on the part of the third respondent, chief officer, the prayer made in the petition that does not survive for consideration. Full stop. Accordingly, the writ petition stands disposed of.
The draft issue. Withdrawing the.
Learned counsel for petitioner has filed a memo dated 13/7/2023 seeking leave of this court to withdraw the writ petition. Full stop. The memo is taken on record subject to all just exceptions. Accordingly, the writ petition stands dismissed as withdrawn.
Suspension report.
Yes.
Directed me to file a detailed affidavit. How many properties am I owning and what is the status of those properties? Filing.
Sorry. Yes, what have you stated?
Which was allotted to the.
Hmm?
1,300 square feet. Still have produced, which is at present it is a vacant site. There are other property number 63/C.
You know?
From third party as well as one side. That is being constructed as apartment.
Sale deed dated 23/11/2012. Annexure R4. It is executed by the society.
Society. Site is adjacent to the block 1 and block 2
Ian Shivkumar avare, I mean Shivaprakash avare.
Yes, sir. Now, two documents are filing. So the first document is concerned. 260, one site it says that he has been allotted, it's kept vacant. The other site which he has filed, so far as these sites are concerned, they said that apartment has been built. And one other site also they have referred a connection of R6 marginal land where R7 and R6 and R7 portion of the marginal land they have purchased. On the third part.
(63/C).
63/C. Another is 11/4. 11/8. Now, my lord, exit saving is not the construction and license and the plan that he has not produced one point. Now the objection filed by the BBMP, my lord, statement of objection, in the morning it is served. May I kindly take my lord to this objection what they have filed.
So one site was allotted by the society. Two other sites you have purchased.
Purchased, it is 63/A and 11/A.
Yes.
Now, the construction is concerned, There is no license or there is no plan which they are not produced as on this day. Number one. Number two, my lord. Place it on record.
ಅಲ್ಲ ಹೇಳಿದ್ದಾರೆ ಒಂದ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 4 ಅಲ್ಲಿ
Question ಆಯ್ತು. ಈ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ದೀನಿ ಅಂತಾರೆ.
no plan sanction plan with a LP number 17 of 2014-15 dated 7/5/2014 issued by the Assistant Director of Town Planning BBMP Madhepura. Paragraph number 4 last line ಕೆಳಗಡೆ last line paragraph number 4.
Second verse so and so. Sanction plan in LP number so and so.
Yes.
This they said that they are constructing.
Yes.
This is so far as the site is concerned. 11 A, nothing is said and no document is produced so far as the construction is concerned. Only sale is produced. Produced.
With regard to 11 stated in the ground compromises, there is a structure, it is a temporary structure, may not there labels are, tenants have been occupied. There is a no permission. I have to demolish the tenants are doing it. 11A, which is our purchase, where the temporary structures are there, where it is being rented out as on date.
Anyway, we will come to that. Now, he has been able to show that he is in possession of 3 sites.
Correct.
One directly allotted by the society.
263.
2 he has purchased.
Correct.
Then what is the difficulty now?
Now, may I kindly take the objection filed by the BBMP? My specific statement of allegation statement is that they are doing a construction on the plots which are reserved for the park and CSI.
ನೀವೇ ಮಾರಾಟ ಮಾಡಿದಿರಲ್ಲ. Society has sold this property, the other 2 properties.
263.
That he has already filed an application, I believe. He has filed an application and will also along with that you have filed a resolution.
Resolution.
We will take note of that and then we'll amend the cost rate. Yes.
Now let us take the objection filed by the BBMP. I kindly take my lord this BBMP objection.
Yes.
Annexure they are filed it. In the annexure A1 malad.
ಅಲ್ಲ ಏನ್ ಹೇಳ್ತಾರ ರಮೇಶ್ what is your instructions? It is not an approved layout.
Despite 1 week. Now,
What had happened? They applied to the society. And when BDA resolution was passed. Sanctioning one certain.
Conditions are to be fulfilled. Yes.
That they did not take.
Yes. So therefore there was no sanction.
This means they are not in this. Now, what photograph it shows. That is not appear. A survey was held. Two plots for AMR for park. Block number 1, block number 4 handed over to us. Nevertheless, it's a private level, handed over to us. I said, no, we have already initiated process, tenders are over, we are maintaining it as a park. The other block number 2 block is still under litigation. Not go there, some other litigations are pending. So what is the my learned produce here? This has nothing to do with that. And even this construction, it you know, he not made a party. As far as block number 1 and block number, what is this document that has here? No, block number the park is being in the summer, one power has been issued on. That's it. So.
Where is your application? ಇದನಾ ನಿಮ್ದು ಅಪ್ಲಿಕೇಶನ್? ಇದನಾ? ಅಲ್ಲ ಅದಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರೆ ಈಗ ವಿಡಿಎ. Without resolution, it cannot be entertained.
Samshuddhi Abhay Sangha. This is not in, is it a welfare association?
But now the picture before Malad is Yuva Sangha. It is also registered society, and where from 1885 onwards it is functioning. All those things I can also produce you. Now, so whereas let me go to locate for the corporation. Annexure A is the document that may can you take Malad to Annexure A?
Do you have a copy of the resolution? There is no resolution. We will not entertain the writ petition.
Because it's earlier to the CMC. The joint inspection of the report was signed and only the area of the park is to protect all of us.
One by one. Now, so where let me go to update for the corporation as well on the election.
Question of going into all those aspects would arise only if you satisfy this court that you have a locus to stand before this court.
Certainly, Malad, I have
If that is not fulfilled, you may withdraw the writ petition and you can file a fresh writ petition at the hands of the society in a manner known to law.
I have a locus. I can place the resolution also on the record before Malad. It is there. It is there.
You have stated it is misplaced.
It is not replaced. It is not.
ನಿಮ್ಮ affidavit ಅಲ್ಲಿ ನಿಮ್ಮ application ಅಲ್ಲಿ you have stated it is misplaced. But inadvertently the copy is not produced along with the writ petition. ಆಯ್ತು, ಇದ್ರ ಕಾಪಿ ಇದ್ರೆ ಕೊಡಿ.
Copy ಕೊಡ್ತೀನಿ. I place it on record. Everything I place it and then only I can check.
Yes.
It is there. It is I placed on record. I placed on record.
ಕೊಡಿ. He says he is the president of the society. He should be having all the information with him. Resolution will be contained in a book. Resolutions of the society will be contained in a book. Anytime you can get a copy of that one. There is no question of saying, no, I don't have a copy.
It is
ಹೇಳಕ್ ಬರೋದಿಲ್ಲ.
already it might be
Yes.
produced and
Yes. We'll have it on Monday. If you want to furnish a copy of the resolution,
And
please furnish. Huh?
Resolution, copy, resolution book also I place it on record.
Yes, yes.
I place it.
Perfect. Learned counsel for the respondent BBMP has filed statement of objections. So a copy of the same is served on the learned counsel for petitioner as well as the contesting respondent. ಅವ್ರಿಗೂ ಕೊಟ್ಬಿಡಿ. Next para. Learned counsel for the contesting respondent number 5 has filed an affidavit of the party along with various documents and photographs. A copy of the same is also furnished on the learned counsel for petitioner as well as the learned counsel for the respondent BBM. Next para. IA number 1 of 2023 has been filed by the petitioner seeking leave of this court to amend the cause title and show the name of the petitioner as Talkaveri Nagara Nivasigala Kshemabhivruddhi Sangha bracketally R, represented by its president. Stop. However, it stated in the application that a copy of the resolution passed by the society to file this writ petition has not been furnished, comma, by mistake. Full stop. Learned counsel for the petitioner submits that if a short accommodation is given, a copy of the resolution and the original resolution book shall also be produced. Stop. Next para. Release this matter on 25th of July. Yes. You know?
Settlement of the file. Party is actually. I will also file affidavit. They told you to fix setback towards the property of the petition.
Learned counsel for respondent number 4 has filed an affidavit dated 19/7/2023 of the 4th respondent. Stop. Learned counsel for the petitioner seeks for a short accommodation to file similar such affidavit at the hands of the petitioner. Full stop. Release this matter on 24th of July.
21st.
Huh? 24th.
Please.
Insofar as the access to the property at the time of construction.
Appear for the petitioner.
Either the university.
Filing an affidavit to the defendant.
Dot.
The affidavit is stated.
Copy of it may kindly be given to me also, my lord.
It has been handed over.
Please, my lord, please.
State that the present or existing access to the petitioner's property. If the completed portion running from the main road to the access. And the same will not be affected by the construction of the parcel by these respondents. This aspect of the matter was discussed with the petitioner. And also explained that to the photograph application are called. I did that it's on the phone with the kids and
stating that the resident of existing access to the property of the petitioner will not be affected by the construction of the class by these restrictions. And the compound C in the photograph is in the acquired portion denoted in yellow color in the next. The same will be demolished by these respondents and the compound and the existing gate use the entrance to the petitioner's property with the mean inside into proposed right of way PR portion, which is denoted in pink color line in the annexed sketch. In the process, the access, which is denoted in orange color in the annex road sketch, will not either be protected or closed by this. Plots I kindly give a clarity note. I produced the picture R3, that is the road sketch. Site access. As shown in the photograph plot connection R4 is denoted in orange color on the right hand corner. Now this is the access where which is being used by them from the main road. Now the pink line at the end of this particular orange color plot, there is a pink line which is running. This compound, as of now, is standing in the acquired portion.
On the yellow portion.
Yellow portion. This will be pushed inside, and to the extent of
It will go inside.
It will go inside.
Ah.
And my lord, there the service road will be in the yellow portion, the acquired portion, the service road will be. This access, whatever they are using as on today, is not this. This is what is happening, which is fine with them. So they were worried only of the access. The access will be cut off, will not be in a position to use the property for which it is being used. The effect.
ಅಲ್ಲ ಈ ಯೆಲ್ಲೋ ಕಲರ್ ಪೋರ್ಷನ್ ಏನ್ ಇದು ಬರೀ ಸರ್ವಿಸ್ ರೋಡ್ ಅಂಡರ್ ಪಾಸ್
that is the service road.
ದಟ್ ಇಸ್ ದ ಸರ್ವಿಸ್
Service road. Lordship is aware that prior to starting the underpass portion, I will have to deviate the traffic. So first I have to acquire this particular portion, construct a service road, deviate the traffic, and thereafter start the underpass. Now, up till I construct the service road, I can't start the project of underpasses. That is why the project basically starts from there. This can always be accepted.
You are appearing for the university. What is your instruction? Yes.
Please, my lord, I just a 2-day accommodation might kindly begin. I'll have a look at the affidavit, my lord, and also seek instructions. In the meantime, I have been told, my lord, that there is a joint meeting that is happening. In fact, I have just received a letter also, my lord, which I will place it on record in the course of the day. The chairman of the vice chancellor of the Bangalore University has written a letter to the BBMP requesting realignment. In principle, my lord, the BBMP have agreed to it. That is what I have been told, my lord. So
they have accepted everything. When the last date, my lord, they made a suggestion that on Monday the meeting is
Not realignment.
not realignment. Not realignment.
I will just take instructions. Days accommodation may kindly be given.
Learned council for the respondent BBMP has filed an affidavit of the executive engineer, road infra bracket RR Nagara close BBMP along with a sketch and photograph. Copy of the same is served on the learned counsel for petitioner as well as the respondent university. Stop. However, learned counsel for the petitioner seeks for a short accommodation to place the affidavit before the party and seek instructions and make submission. We'll stop. Release this matter on 24th of July, Monday.
Yes, interim stay may kindly be extended.
Not in a position to start the project also. Unnecessarily.
I think we will be able to dispose of it on 24th.
Maybe in this week itself.
Even Friday and the Nadidago.
Monday, my lord. I would request.
He is only accountable to the tenant, but he cannot have any voice in so far as these matters are concerned.
We'll do it, yes, 24th.
Interim stay may kindly be extended.
Interim order granted earlier stands extended till next date of hearing.
Highly obliged. My
J.
Planning. Action without obtaining license sanction plan. My learned friend served a copy. They have passed an order. Permission order came.
So Girish, DS. The petitioner was aggrieved of the inaction on the part of the respondent, DBMP authorities. In respect of a complaint given by the petitioner complaining that respondent number 4 herein has been putting up construction and without obtaining plan, without obtaining building license or sanction plan. Stop. Next para. Learned counsel for the respondent BPMP has today furnished copies of it is filed along with a memo. Filed a memo dated 19/7/2023 along with copies of the provisional order passed under section 248(1) of the BBMP Act 2020 and a confirmation order passed under section 248(3) dated 11/5/2023. Stop. In that view of the matter, this court is satisfied that action has been initiated by the third respondent, assistant executive engineer, ward number 23, BPMP against the fourth respondent. Stop. However, the third respondent shall continue in accordance with law and take the proceedings to its logical conclusions. So, if no appeal is filed by the fourth respondent before the chief commissioner, then the third respondent may proceed to secure orders for demolition of the unauthorized construction. Stop. Ordered accordingly. Writ petition stand dispose of Banta. Yes.
Directed me to use the it should be the hospital. The security documents.
Change of either.
Security certificate issued by the by way of the court martial. First time I have secured the birth certificate in the year 2016. What basis, my lordship, my daughter was admitted to the school. That was the question posed by lordship. I secured the lordship of the document issued by the hospital. So I put on record.
Hospital.
Hospital. But in the body there.
Allala. For admission of the child to the school, You were required to produce a birth certificate. When did you obtain that and produce it before the school authorities? 2008. So therefore you should be having. Correct. That is what I said. Normally, we don't have this custom of naming the child immediately when it is born. So therefore, all our birth certificates do not contain the name of the child. It contains only the gender and the name of the parents and the place where it is born, time. This information sigutta. Usually, the name of the child is not there, but the name of the mother and father is definitely there. ಈಗ ಅದರಲ್ಲಿ ಏನಂತ ಐತೆ ಹೆಸರು? Name of the mother. Seventy. How? Mistake. Mistake ಹೆಂಗಾಗುತ್ತೆ ನವೀನ್? ಅಲ್ಲ ಆಮೇಲೆ ಏನಾದ್ರು ಬದಲಾವಣೆ ಮಾಡ್ಕೊಂಡ್ರ ಹೆಂಗೆ ಏನು ಹೌದು ದೆನ್ ಅಲ್ರಿ ಸ್ಕೂಲಿಗೆ ಸೇರ್ಸೋವಾಗ್ಲೂ ನಿಮ್ಗೆ ಅದು ನೇಮ್ ಆಫ್ ದಿ ಫಾದರ್ ಅಂಡ್ ಮದರ್ ಚೆಕ್ ಮಾಡ್ಲಿಲ್ವಾ? At the request of learned counsel for petitioner, release this matter on 26th of July. ಇಲ್ಲ ಅಂತಂದ್ರೆ you will have to go before the magistrate or civil court. Is this matter of the service of notice on response number 2 to 4? Date ಬರಲ್ಲಮ್ಮ. Non-filing of memo acknowledgement for rupees 3 lakhs.
Directed the petitioner to pay it 3 lakhs. Get the entry model, not paid the amount.
Cooperative society. ಕೇಳೋರು you will be wasting the time of the court. Yes. ನಾಳೆ ಇದು auction. You may proceed. By order dated 10/7/2023, while this court noticed the fact that the auction is scheduled to be held on 27/2023, this court directed the petitioner to deposit a sum of rupees 3 lakhs with the third respondent and furnish an acknowledgement. Stop. However, learned counsel for petitioner submits that the petitioner could not deposit the said sum of rupees 3 lakhs. Full stop. Next para. In that way of the matter, no benefit of interim order can be made available to the petitioner. Stop. The third respondent may proceed to conduct the auction as scheduled. Yes. Okay. But is this matter after service of notice on respond number 5?
Or is the election is there? Where is the departure, there is no departure list is furnished by the.
ಓ ಇದು ನೆನ್ನೆ ಬಂದಿದ್ದ ಮ್ಯಾಟರ್. ಹಾ ಏನ್ ಮಾಡೋದು? ಹಾ ಹಾ but where is the list? They have not prepared a list. ಮತ್ತೆ ಏನ್ ಮಾಡೋದು? ಅದೇನೆ which is that provision?
13D.
Very manual scale. Manual because they're being manual is not maintained. They have to avoid it.
If I issue the department list, then I had it.
E-list, they are not eligible.
Sir, ಅದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗೋದು. Please understand, if you are aggrieved of your name not being found in the eligible voters list, you will have to approach the competent authority seeking inclusion of your name. Unless your name is found in the eligible voters list, why should this court direct or permit you to participate in the election? In all those cases, there was a list of defaulters and the coordinate bench held that kind of disqualification without issuing notice would be contrary to the law. And therefore, as an interim measure, all such persons whose name was found in the defaulters list were permitted to participate in the election. Nim case alla ತರ ಇಲ್ಲ. On what ground can we direct or allow you to participate in the election?
The name is not there in department list.
ಅದಕ್ಕೆ you will have to raise a challenge before the competent authority.
They have to follow section 13D itself.
ಹೌದು.
Procedure itself has been not followed.
Here ಹಂಗಾರೆ ಫಾಲೋ ಮಾಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ಬೋದು ಅಷ್ಟೇ ನಾವು. Your grievance is that your name is not found in the eligible voters list. For that purpose, you will have to approach the competent authority to have your name entered in the list. Huh?
I am not opposing the election.
You want to cast your vote ಅಷ್ಟೇ.
What try to
ಅಲ್ಲ ಇವತ್ತು ಎರಡು ಮ್ಯಾಟರ್ ಇದೆ ಆ ತರದ್ದು. ಇಲ್ಲ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಇದೆ ಸೇಮ್ ಸೊಸೈಟಿ. Rule 13D. So that list of eligible voters. ಅದಲ್ಲ. Sub rule 1 says election officer shall. ಅಲ್ಲಲ್ಲ 1 ನಲ್ಲಿ election officer shall after due verification send a consolidated list of all cooperative societies in the district where elections are due at least 120 days before the date of expiry.
term of the office.
Election officer shall take steps for publication of voter list in the online manner.
Yes.
Number 1, A for publication of draft eligible electoral list, a list of draft default.
So defaulter list, they are not done in this case. List of members who payment for due before the election.
Sorry, Parkal. Learned counsel for the petitioner submits that in terms of clause A of sub-rule 3 of rule 13 capital D of the Karnataka Cooperative Societies Rules, 1960, the respondent election officer was required to publish a draft eligible electoral list, a list of defaulters, a list of members whose repayment falls due, before the election date, clear 15 days. Stop. However, the respondent election officer has not published a list of defaulters. Stop. Therefore, it is submitted that the petitioner cannot be debarred from participating in the elections. Stop. However, learned counsel for the petitioner would further add that it would suffice if the petitioner is permitted to cast his vote in the elections scheduled on 20th of July 2023. Stop. Next para. Accepting the submission of the learned counsel for petitioner, a direction is issued to the respondent returning officer, fourth respondent returning officer, to permit the petitioner to cast his vote, to cast their votes in the election scheduled to be held tomorrow for the fifth respondent. Election for election for electing the president and president.
For electing.
For managing committee. ಅದೇ ಜನರಲ್ ಎಲೆಕ್ಷನ್ ಅಂದ್ರೆ ಹೇಳಿದೆ.
In submission of the learned counsel for the petitioner, a direction is issued to the fourth respondent returning officer to permit the petitioner to cast their votes in the election scheduled to be held tomorrow. For the fifth respondent.
To the board of the fifth respondent society. Stop. Allah, I am not disposing of the matter. Allah, adana bantalo bandilva adu. No, they have not published the list of defaulters at the bandide. Read this matter on 26th of July.
Yes, 29.
29 also same. Yes. ಇದೇ ತರನಾ ಸೇಮ್ ಸೊಸೈಟಿ ಸರಿ ಸೇಮ್ ಆರ್ಡರ್ ಕಾಪೀಸ್ ಕೊಡಿ ಅವರಿಗೆ. ಅದ್ ಬೇರೆ, ಇವರು ಎಲೆಕ್ಷನ್ ಅಥಾರಿಟಿ. ಪ್ಲೀಸ್ ಗಿವ್ ಎ ಕಾಪಿ.
ಏನಂತಂದ್ರೆ ಅವ್ರನ್ನ ರೆಂಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಒಪ್ಕೊಳ್ತಾ ಇದ್ದಾರೆ. ಹಾಗಾಗಿ ಹೇಳಿದೀನಿ ಪಾರ್ಟಿಗೆ ಒಂದು ವಾರ 10 days ಟೈಮ್ ತಗೊಳ್ಳೋಣ, ಇನ್ ಕೇಸ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋಣ ಅಂತ.
At the request of the learned counsel for petitioner, release this matter on 26th of July. Modification. Yes, you are required to clarify.
Enforce the building rate or the municipality. 2 kilometers road, there are so many violations of building rate.
Inside the town.
Yes.
Inside the town, yes.
National Bank declared very recent. They want to not building rate, state not. National Bank are take care. Or else not keep, it's why they want to enforce not. Tomorrow they make case for paying
You are
compensation.
appearing for whom?
And municipality.
Municipality. What is the grievance of the petitioner?
Even if not, they have constructed a building not, the major violation is not have to do, so it's an art to pay name kind of.
So you wanted to take action.
Because it's not building like not have violated. Building like no national union building. It's a road like
Lalla.
base name of the counter. And quite problem to arm. Name was sketch have produced.
No, is it a case where they had obtained a building license and they had put up construction? They have not obtained building license.
Again, it was 2000 they have obtained, but that last it's not, for 10 years again they went on. Earlier license was only for 2 years, when that has lapsed. Recently, not, another thing, not they have not obtained it. They take to the page number 9.
Yes, yes.
Is the investigation that happens.
ಇದು ಈ ಮ್ಯಾಟ್ರು 2019 ಇಂದ ಪೆಂಡಿಂಗ್ ಇದೆ. What have you done with the other buildings on the road? ಅಲ್ಲ ರೋಡ್ ಬೈಂಡಿಂಗ್ ಆಗೋಗಿದೆಯಾ? ಮತ್ತೆ
Declare in the national highway.
ಹಾ
Building lane violation can be placed 9.
because they have undertaken the construction now,
Yes.
you have issued notice.
Yes. And no, the building lane inspector is not enforced, or it's making case for competition. Therefore, national highway, they declare in national highway, they have to implement the national road lane. Building lane, road lane.
Please tell your senior. He'll have to come and say before this court whether they have gone ahead with the construction, what is the present position. You dispose of the matter on the next date of hearing.
Smart plan.
ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ
That's why.
ಈಗ in the interim
Not even before that. Construction is in violation, therefore, the adjusted landowner
complaint.
has to file a complaint.
At the request of learned counsel for petitioner, release this matter on 26th of July. No further adjournments will be given. Yes. Court notice. ಯಾರಿಗೆ? ಯಾರಿಗೆ ಇಶ್ಯೂ ಮಾಡ್ಬೇಕು ನೋಟಿಸ್? ಪ್ರಿಪೇರ್ ಆಗ್ತದಕ್ಕೆಲ್ಲ ಇಲ್ಲ ಏನ್ ಬೇಕಾಗಿಲ್ಲ, ಏನ್ ಬೇಕಾಗಿಲ್ಲ. ಅಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ಸ್ ಯಾರ ಹೆಸರು ಯಾರು ತೋರಿಸ್ಬೇಕು ಅಂತ ಇಲ್ಲ, ಪರವಾಗಿಲ್ಲ. ಅದನ್ನ ತೆಗೆದ್ಬಿಟ್ಟು ಅಡ್ವೊಕೇಟ್ ಹೆಸರು ತೋರ್ಸೋದು ಬೇಡ. Shivkumar ಅವರೇ, the court officer is saying in some of those matters, Allah, Justice Vishwadit Shetty ಅವರು, he was appearing for some of these petitioners. I think court order was directed to be issued to the petitioners. It's all right, now we have disposed of the matter, but you should at least bring it to the notice of the petitioners. ಅವರು ಇದು advertisers, so that they will be able to file their objections. Yes. ಏನಕ್ಕೆ ಗೊತ್ತಾಯ್ತು?
That not it is more than 200 meters.
There
is no impediment for them to give the permission.
My lord, amendment is made in the zone. Within 100 meters, there is no development. For a 200 within 200. Not only that point, my lord, other points is also there. We have stated in our endorsement. The public interest is not, and no development further advocate land is concerned.
Sir, I have been telling you, please understand, the very concept of town planning is to provide for housing. It is not meant for this mines and geology. Your submissions is totally contrary to the very scheme of the Town Planning Act. The planning is meant for a planned development of a residential area, a town, a city. Alli, even if you have earlier, there were some mines and mineral activities that were going on, they have to be shifted out. Correct, sir. They will have to shift out. It is not that these people have to be prevented from making use of their property for a better beneficial use.
Five points of that. Such development. And also, my lord, putting land industrial in there, that's aware of that.
I don't know why he is raising always not new things are being brought over. But what is his interest?
Sen Chandrasekhar, very clear, not aware of that. In the residential areas, commercial is not given the permission. In respect of my lord, I have that judgment. Very clear, he said that one. All change of plan is just of the public mind. It is a kindly similar point. Endorsement can, they have given 5 reasons. ಈಗಾಗಲೇ ದಿನಾಂಕ 28/5/2023 ಅಲ್ಲಿನ ಪ್ರಾಧಿಕಾರ 71ನೇ ಸಭೆಯ ವಿಷಯ 29 ಉಲ್ಲೇಖಿಸಿರುವ ಪ್ರತಿ ಜಾಗೆ ವ್ಯವಸಾಯ ಕಾಯ್ದೆ ಅಭಿವೃದ್ಧಿಗಳಿಗೆ ಸುಮಾರು 1.5 ಕಿಲೋಮೀಟರ್ ಪ್ರಗತಿ ಜಾಗ ಮತ್ತಷ್ಟಾಗಿರದೆ ತಪ್ಪುಗಳಿಂದ ಮಹಾಯೋಜನೆಯಲ್ಲಿ ಕೈಗಾರಿಕೆ ಉಪಯೋಗಕ್ಕೆ ಕಾಯ್ದೆ ಜಾಗ ಹೊರಗಡೆ ಬರುವುದು ಪ್ರತಿ ಬೆಳವಣಿಗೆ ಹಾಗೂ ನಿರ್ವಹಣೆ ಮಾಡುವುದು
Allah, this will again be in contravention of the very purpose of identifying this area for town planning. Please understand.
252,000
Once you identify an area for town planning, naturally in the outskirts there may not be development. But for the purpose of a planned development, in order to ensure that in which place residential area has to come, in which place industries have to come, either planned growth goskara, you are in existence. You can't say, al moolelli yavadu development illa, adrinda ivrige permission kotre.
That is the reason, my lord, based on Supreme Court judgment, the guidance issued by the government. However, it is important to ensure such development and permitted can be integrated in overall for the city. The basic object of the agency we are provide for the regulation of the land use of land use development. Provisions stated very clear that such changes permitted should not be against the basic spiritual intent of the act. Further, change should be not jeopardized.
Allah, you again, you change of land use keltadara. Change of land use from
change of land.
Agriculture in the residential area. Particularly now, there development in London. Particularly industrial area. There is no such development in respect of residential area. Okay, now photograph.
AIDB has given an endorsement on 252,000. I have produced that endorsement.
we'll consider. You consider. You want it to be listed on 26th? Huh?
They leave also because so many things have happened. I have a list of events also.
At the request of learned counsel, Sri Yogesh D. Naik, appearing for the respondent planning authority, release this matter on 27th. Please come prepared for final disposal.
All these are answered in the previous writ petition.
Yes.
Deciding to the same matter. Along with the other respondent. Along with the other respondent, R5 is also residing. He is avoiding service of all the other respondents have taken court notice. Therefore, I have not for subserving by way of paper publication.
ಮೂರ್ ಸರಿ ಆಗಿದೆಯಾ? I don't think so. That was what we noticed last time also. Otherwise, we would have allowed it last time itself. Check out once more, we'll see.
But this application is pending
Yes, yes. The petitioner is required to take out notice to respond number 5, comma, at least thrice, comma, before seeking permission to take out notice by way of substituted service. Full stop. Therefore, the petitioner is directed to take steps for service of notice on respond number 5, comma, within a week today from today. Yes. Again, let it be there. Learned Counsel for petitioner has filed a memo dated 19/7/2023 stating that whoever has filed it, he is permitted to withdraw. Yen ಮಾಡಕ್ಕೆ? Stating that the petitioner is unable to comply with the office objections, and therefore the petitioner may be permitted to withdraw the writ petition. So, liberty is also sought to file a fresh writ petition on the same cause of action. Full stop. Next para. In view of the memos taken on record subject to all jurisdictions. Stop. Accordingly, the writ petition stands dismissed as withdrawn, comma, reserving liberty as prayed for. No, let us see. Next time over hangge madidre you may raise objection. Yes. Was filed this memo for posting, IA for posting. IA no.
Was suspended suspension by the Secretary of the Respondent Place Society.
Hmm.
And thereafter, with the notice, first notice. And the inspector accepting my explanation as directed me to register the society as a secretary. Thereafter, I was not permitted to work by the newly elected managing committee. No, after even without permitting me to work, no, they have passed the resolution, keeping me under suspension. Where I have not been all in the service and where I have not been permitted to work. And now they have passed a resolution.
Now notice issue madilva.
Notice issue, KVT hakiದ್ರು, KVT served KVT on 15/4/23. And they have sought for time and.
I am appealing for respondent society in this matter.
Yes. Yes.
Statement of objection is ready, Your Lordship. Week's time may be granted. I will serve the copy on the petitioner counsel and I will file before the court, Your Lordship.
Learned Counsel.
Back and you see the hardship sought for time.
Sri G. Chandrasekharaya. Appearing for respond number 3, society submits that statement of objections are ready and the same will be filed. Yavaga? Within a day or two. Full stop. Release this matter on 26th of July 2023. Full stop. In the meanwhile, statement of objections may be filed with a copy served on the learned counsel for petitioner.
Respect to rejection of online application right for building permit.
Hmm?
Already covered lot by a lot of precision in WP number 15298 for 2020.
Hmm.
If it is note which has been formed prior to RFP 2015.
ಇದಾ buffer zone.
Produce that at
When was this layout formed? VDA layout. VDA layout. Huh?
It was purchased in 1979.
79.
78. It was gifted to the son, connection 3. Page number 19 is the recital.
Paklam. Learned counsel for the petitioner submits that the petitioner is aggrieved of the impugned communication dated 30/1/2023 at Annexure A. It was directed that the petitioner will have to leave a buffer zone of 25 meters from the center of the stormwater drain abutting the property in question. Stop. Learned counsel for the petitioner submits that the question as to whether the buffer zone in terms of the RMP 2015 and the zonal regulations will have to be left in layouts formed prior to the year 2015, comma, is no more res integra, comma, since the said issue has been considered and laid at rest in the case of Sri Pawanjit Singh Sandhu versus Brihat Bengaluru Mahanagara Palike and others in WP number 15298 of 2020, dated 6th of April 2021. So, next para. ಅದು ಇನ್ನೊಂದು ರೀಸೆಂಟ್ ಆಗಿ ಮಾಡೋದಲ್ಲ, ಒಂದ್ 2 ವಾರದಿಂದ ಅದನ್ನ ಚೆಕ್ ಮಾಡ್ಕೊಂಡು ಅದು ಲಾಸ್ಟ್ 2 ಪ್ಯಾರ ಅಲ್ಲಿಂದ ಹಾಕೊಳ್ಳಿ. ಆಮೇಲೆ ಅದಾದ್ಮೇಲೆ having regard to the said legal position, this court finds that the layout was formed much prior to the year 1979. Stop. The petitioner's father, Sri Rajiv Jain, had purchased the property in question under a registered sale deed dated 24/10/1979. Stop. The petitioner acquired the property under a registered gift deed dated 29/1/2020. Stop. Therefore, it is clear from the material available on record that the layout in question, the layout in which the property in question is situated, was formed much prior to the year 1979, and therefore the requirement of leaving the buffer zone next to the stormwater drain, would not arise in the present context. Full stop. Adರಲ್ಲಿ last paragraph operative portion. Grandfather. Your application has been rejected, or what is this? It has been rejected. So therefore you'll have to file a fresh application. We have said so in that operative portion. Yes.
Went to 2022. After 1 year, not. Action petition. Here again, you dispose of, direct the disposal, election.
ಇವರು ನಿತ್ಯಾನಂದ್ ಅವ್ರು ಇಲ್ವಾ? In that other matter, he was pointing out, ಇದು this arises out of the Gram Panchayat Act, Cooperative societies. Election petition. Dispute. The petitioner is before this court seeking a writ of mandamus directing the first respondent, Deputy Registrar of Cooperative Societies, Kodagu District, to dispose of the dispute, dispose of the matter in dispute number 3 of 2022-23, filed by the petitioner, invoking the provisions contained in invoking section 70 of the Karnataka Cooperative Societies Act. Stop. Next para. Although notice is served on the contesting respondents, they have remained unrepresented. Full stop. Moreover, the prayer made in the writ petition is innocuous. Full stop. The petitioner is only seeking a direction to the deputy registrar of cooperative societies before whom a dispute is pending consideration from 22 to 2023. 7/2022. So, the petitioner is only seeking a direction to the authority to dispose of the matter within a time frame. Full stop. As per accepting the submission of the learned counsel for petitioner, this writ petition stands disposed of with a direction to the first respondent, deputy registrar of cooperative societies, Kodagu district, to dispose of, to consider and dispose of the matter in dispute number 3 of 2022-23 filed by the petitioner, as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order. Stop. Ordered according.
Entering application file marketing file marketing is not entered. Despite the want the registry and filed the entering application. Section 64 inquiry is under challenge before the Honorable Court. When the section 64 inquiry is still in progress, that's what this particular officer does. He has a very peculiar mode of functioning so far as the society is concerned. Initially, he initiates 1665 inquiry when the previous board was in existence. Then that section 65 inquiry came to be stayed by the Honorable Court because that was already inquired into and the report had already been generated. Then some of the directors resigned as a result of it. There was no quorum. Special officer is appointed. The special officer is in charge of the affairs of the society. This very person institutes an inquiry under section 64 of the Act. When there is a special officer. Then we came before this Honorable Court and then sought for elections to be conducted. Elections was conducted. The new board came into existence on 17/3/2023. They took charge. But this third respondent passes an order on 10/4/2023. Don't register the sites. I fail to understand where he gets the jurisdiction to give such directions. If he is conducting an inquiry under section 64, he has to wait till the conclusion of the inquiry under section 64, and the report of the inquiry should be communicated to the society. Under section 68 for its compliance, there also the society has a right. Once an inquiry report comes on section 68, directions are to be done, then society will have directions. Interim orders are never recognized under the scheme of the Act. This is virtually like administering the society itself, meddling with every affairs of the society. Now, what this very officer does is, he grants a stay. Don't make any allotments to the previous board. Notice if your losses, see how he does it. He grants a stay. Then he gives a list of members to whom he wants the allotments to be made. First occasion, of course, the allotments were not done. I'm speaking about the previous board. Then he vacates the interim order. Again, he grants one more time, he grants an interim order. That again he vacates because some allotments were made. Then again he makes one more stay order saying that these are the people to whom you have to make the allotment. Thereafter, once vacates the interim order. This is the modus operandi of this concerned officer. But now, what actually is happening is there is a group of people. The person who wants to get himself implemented is a person who has admitted to membership in the year 2020. The allotments have been made in 2018 and before 2018 itself. What is remaining is only registration. No member has raised a dispute under section 70 that their seniority has been overlooked and the membership, the seniority has been overlooked or that the allotment has been made. Let's kindly have a look at the memo which has been filed by me. What is the present state of affairs? I just pass on this memo. This is the present state of affairs. This states are concerned.
Only one person is seeking to come on record.
Yes. And he is a 2020 enrollee. The reason why this person is set up is because we have made this DRCS as the party in person. Because I will be in a position.
We are not deciding as to, or we can't issue direction as to whom the sites have to be allotted or anything like that. The society is before this court, aggrieved of the action of this joint registrar. And therefore, you cannot have any grievance of the dispute brought before this court. This dispute can be decided without your presence. You are not a necessary party to these proceedings.
I am the member of this society.
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು. This court is not deciding or giving directions. ನೀವು ಯಾರಿಗೆ ಸೈಟ್ ಕೊಡಬೇಕು, ಯಾರಿಗೆ ಸೈಟ್ ಕೊಡಬಾರದು ಅಂತ we are not considering that aspect of the matter. Therefore, this is not a case where your presence is necessary. If you are aggrieved of any action of the society in not granting you the allotting you the site, then the dispute can be raised before the competent authority. This is not a forum where you can agitate or come on record, because this is not a matter pertaining to whom the sites have to be allotted. Berkeley. Order on IA number 3 of 2023. This application is filed by Sri Jayanna HM, seeking to come on record as a party respondent to these proceedings. Stop. Learned Senior Counsel Sri D.R. Ravishankar, appearing for the petitioner society, submits that the writ petition has been filed by the society, aggrieved of certain orders and directions issued by the fourth respondent, Joint Registrar of Cooperative Societies, and the grievance of the impleading applicant is regarding allotment or non-allotment of the sites at the hands of the society. Full stop. That grievance cannot be agitated in this writ petition, since the writ petition, the petitioner society is not the petitioner society is only before this court, is before this court only to seek certain directions to the joint registrar. Full stop. At any rate, the impleading application cannot be allowed, since the impleading applicant is not a necessary party to these proceedings. Full stop. Next para. Learned counsel for the impleading applicant seeks to submit that the petitioner society is not following the rule in the matter of allotment of sites. Stop. Having heard the learned senior counsel for the petitioner and the learned counsel for the impleading applicant, this court is of the considered opinion that the impleading applicant cannot be a necessary party to these proceedings. Stop. The issue brought before this court at the hands of the petitioner society has nothing to do with the allotment of sites. Stop. the impleading applicant may approach the competent authority if he is aggrieved of the non-allotment of sites. Full stop. For the reasons above stated, comma, the impleading applicant application stands rejected. Full stop. Next,
Because now. Your lordship should take the memo which I write, typically what we are facing is. But the society has formed 3 layouts. Can you have a look at page number 2?
no, what directions had we given last time?
Now direction says, for the allotments which are made before 2018, we have made the allotment from 1990 to another 2018. The registrar now says, pending inquiry under section 64, don't register the site.
Yes, madam. Have you informed the concerned officer? What instructions? Huh? ನೀವು ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ತಗೊಂಡಿದ್ರಲ್ಲ, ಏನಾಯ್ತು? He has been served.
Next year, G, which is under challenge at page number 29. Not in WP number 11911 of 2023. It says pending inquiry under section 64. Interim orders are passed. The question is whether the registrar has any such jurisdiction under section 64 or not. What if I kindly have a look at section 64?
We'll continue at 2:30.
Got it. ಇದಷ್ಟೇ ನಾನು ನನ್ನ ಹತ್ರ ಇದೆಲ್ಲ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು ಚೇಂಬರ್ ಅವರಿಗೆ ಬೆಳಗಿಂದ ಚೇಂಬರ್
ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಇದು ಐಎ ಬೇಗ ನೋಟಿಸ್ ಹೋಗಿದೆ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ ಆದ್ರೆ ರಾಂಗ್ ಅಂತ ಅವ್ರು ಬರೀತಾರೆ ಬ್ರಾಂಚ್ ಏನಾಗಿದೆ ಆಮೇಲೆ ಎಲ್ಲ ನನಗೆ ತೋರಿಸ್ತೀನಿ ಅದರಲ್ಲಿ ಅದೆಲ್ಲ ಇಲ್ಲ ಎಲ್ಲ ನೀವು ಆಮೇಲೆ ನೋಡಿದ್ರೆ ಈ ಬೇಗ ಕೈ ಬಂದಿದೆ ತೋರಿಸಿಲ್ಲ ಅಂತ ಇನಿಷಿಯಲ್ ತೋರಿಸಿಲ್ಲ ಇದ್ರಲ್ಲಿ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಅವ್ರದ್ದು ಹುಡುಗ ಇವಾಗ ಬಫರ್ದು ನನಗೆ ಕಳ್ಕೊಂಡಿದೆ ಎಷ್ಟು ಅಂತ ನೋಡೋದು ಎಲ್ಲಕ್ಕೂ ತೋರಿಸಿ ಅದು ಬರೀ ರೆಸ್ಪಾಂಡೆಂಟ್ ಬರ್ತಾರೆ ಕರೆಕ್ಟ್ ಇದೆಲ್ಲ ಅವರು ಅದರಿಂದ ಪ್ರಾಬ್ಲಮ್ ಮತ್ತೆ ಒಂದ್ ದಿವಸ ಬಂದು ಮತ್ತೊಂದು ದಿವಸ ಬಂದಿಲ್ಲ ರೆಡಿ ಮಾಡ್ಕೊಂಡು ಅದು ಅಲ್ಲ ಹೇಳ್ತೀನಿ ನಾನು ಈಗ ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಿದ್ದೀನಿ ಆಗ ಹೇಳ್ತಿರ್ತೀನಿ ಊರಾಗ ಪ್ರಾಣ ತುಂಬಿರ್ತಿದ್ರು ಅವ್ರಿಗೆ ಹೇಳಿ ನಾನು ಲೇಟ್ ಆಗಿ ಕೊಡ್ತೀನಿ ಮತ್ತೆ ಹೇಳ್ತೀನಿ ಆಯ್ತು ಕೊಡ್ತೀನಿ
Ah.
ನಾನು ಮನುಷ್ಯ ಅದಕ್ಕೆ ಹೇಳಿದೆ ಸಾರ್ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಇವರು ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಮಾಡ್ತಾರೆ ಇನ್ನೊಂದು ಅವರಿಬ್ರು ಹಂಚ್ಕೊಂತ ಇದ್ದಾರೆ
ಸನ್ಮತಿ ನೀರಲ್ಲಿ ಆಮೇಲೆ ಸನ್ಮತಿ ಅಪ್ಪ ಇಂದಿರಾ ಕುಮಾರ್ ಸನ್ಮತಿ ಅಪ್ಪ
ಸಮ್ಮತಿ ಅವರು ಇಬ್ರು ಹಂಚ್ಕೊಂತ ಇದ್ದಾರೆ
ಸರ್ಟಿ ಚೆನ್ನಾಗಿದೆಯಲ್ವಾ ಸರ್ಟಿ ಚೆನ್ನಾಗಿ ಏನಪ್ಪ ಇದೆ ಎಲ್ಲ ನೀವು ತೋರಿಸ್ಬಿಡ್ತೀವಿ ಏನಿದೆ ಅಂತ ನೀವು ತೋರಿಸ್ಬಿಡ್ತೀವಿ ಪ್ರಸಾದ್ ಇವರು ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ ಎಲ್ಲೆಲ್ಲ ಪ್ರಸಾದ್ ಅಂತ ಅವೆಲ್ಲ ಅವ್ರದೇ ಏನಿದೆ
ರಾಮಚಂದ್ರ
ನರೇಂದ್ರ ಗೌಡ
ನಾರಾಯಣ ಗೌಡ
ಅಶ್ವಿನಿ ಸಾಗರಿ
और टीवी करते
डॉक्टर रामकृष्ण नरेंद्र
Election. Election. ಅದು ಮತ್ತೆ
Hearing on them.
So
ತಗೊಳ್ತೇನೆ. ನಾನು ಬರಲ್ಲ ಅನ್ಕೊಂಡೆ. ನನಗೆ ಆಸೆ ನಾನು ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
30 days time.
ಎಲ್ರಿ ಇವಾಗೆಲ್ಲ ಆಗೋಯ್ತಲ್ಲ ಕ್ಯಾಲೆಂಡರ್ ಆಫ್ ಇವೆಂಟ್ಸ್ ಅನೌನ್ಸ್ ಮಾಡ್ತವ್ರು ಇವಾಗ ಬರ್ತಾ ಇದ್ರಿ ಬಂದ್ರು ತಿರ್ಗಾ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿ ನಾಡಿದ್ ಬರುತ್ತೆ ಅದು ಏನ್ ಪ್ರಯೋಜನ ಇಲ್ಲ ಆಯ್ತು ತಗೊಳ್ಳಿ Yes.
Application serial number 38. What I see the memo which I. Page number 2. First layout which was found was in 1992. This is called as Yarapnalli Badavade. Adರಲ್ಲಿ we have indicated that we have developed this in blocks, totally 9 blocks. All allotments are made prior to 2018. We have 1% sites of allotted in the year 95-96. Some properties fell in dispute. Civil suits were pending. After the civil suits were either compromised or disposed of, then the additional sites which were there were distributed in the year 2018. That is how the 2018 allotments. Otherwise, this is an allotment which took place in 92 to 95. In this first stage, can you have a look at page 4? 175 sites are pending for registration. Out of 3003 sites, that's the kind of look at page for the bottom of the page. 3003 site ಅಲ್ಲಿ 2563 ಸೈಟ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗಿದೆ. 175 ಅಲಾಟ್ಮೆಂಟ್ ಆಗಿದೆ, ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗಿಲ್ಲ. 265 ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಇದೆ, ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಆರ್ ಪೆಂಡಿಂಗ್. ಸೊ ದೀಸ್ ಸೈಟ್ಸ್ ಆರ್ ನಾಟ್ ಅಲಾಟೆಡ್. ಲೇಔಟ್ ಪ್ಲಾನ್ ಅಲ್ಲಿ ಇದೆ, ಬಟ್ ಸೈಟ್ಸ್ ಯಾರು ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಿಲ್ಲ. This allotments are not challenged by anybody till date. We are in 2023. Can you have a look at the next page? ಲಿಂಗೇಂದ್ರಹಳ್ಳಿ ಬಡಾವಣೆ ಇದರಲ್ಲಿ ಒಂದು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಪೆಂಡಿಂಗ್ ಇಲ್ಲ. ಇದರಲ್ಲಿ ಏನೋ ಡಿಸ್ಪ್ಯೂಟ್ ಇರಲಿಲ್ಲ. 3059 3059 ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿಸ್ಬಿಟ್ಟಿದೆ. ಇದ್ರಲ್ಲಿ ಸುಮಾರು 2000 ಮನೆ ಬಂದಿದ್ದಾಗಲೇ. ಇದ್ರದ್ದು ಏನು ಸಮಸ್ಯೆ ಇಲ್ಲ. ದೊನ್ನೇನಹಳ್ಳಿ ಬಡಾವಣೆ plots may kindly see in this 128 sites are called, 109 sites are distributed and registered. 19 sites are remaining for registration. Even this is done in 2006-2007. ಈ ಮೂರನೇ ಬಡಾವಣೆ 2002 ಇದೆ. ಫಸ್ಟ್ ಹಂತದ ಬಡಾವಣೆ ಮಾತ್ರ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ, ಈಗಲೂ ಪ್ರಾಬ್ಲಮ್ಸ್ ಇದೆ. ಸ್ವಲ್ಪ ಪೆರಿಫೆರಲ್ ಅಲ್ಲಿ we are facing problems with civil litigations which we are trying to resolve it, which we are unable to do it. Now the registrar initiates inquiry under section 65 at the first instance. Every time he is saying that don't make allotments, he vacates the order after the allotments are made in the name of the person. So he suggests one of the members. That is the modus operandi of the joint registrar. He initiates inquiry under section 65 inquiry stated by the Honorable. Some of the directors resign, there is no quorum, special officer. And the special officer is in charge of the affairs of the society, who is none other than the official of the cooperative department. He initiates an inquiry under section 64 of the Cooperative Societies Act. Then we find a repetition in which the direction was given that the election should be conducted for the new board. On 17/3/2023, the new board comes into existence. He passes an order on 10/4/2023 at Annexure G, page 29. Don't register the sites. At page 30. He says, in lieu of an inquiry which I have initiated under section 64, don't register the sites. But now the only question which I am raising is this. He is certainly entitled to conduct an inquiry. There is another repetition where I have challenged section 64 inquiry itself. Because he wants to inquire into the affairs of the society of the previous board, and then the special officer is in charge of the affairs. Against the new board, you cannot conduct any inquiry. But now, if he holds an inquiry under section 64, it may result in the report. Now, what happens to the report is dealt with under section 68 of the Act. If your lordship is going to see the powers which are given under section 64, he cannot pass interim orders. He can only conclude the proceedings and then give directions in terms of section 68, which is required to be complied with by the society. But this kind of interim orders is never permitted to be granted under the scheme of the entire Act. Interim order powers is of the very section 17 only. And he does not refer to any provision of law also as to from where he derives the power for granting of an interim order. The reason why I produced this memo is because 2006-2007 third stage layout, 2002 second stage, 92 to 95 first stage. It is only because there were civil disputes and additional sites were added on account of either additional lands available because of clearance of the civil dispute. Some sites are still remaining. That is also now being troubled with. The lordship is going to see Annexure J series, how this joint registrar has conducted himself. Annexure C, page 21. The same officer.
No, Annexure G.
Annexure G, page 29.
ಈ ಕಚೇರಿಯ ಕಲಂ 68ರ ಆದೇಶದ ವಿರುದ್ಧ ಸಂಘದ ಮಾಜಿ ಕಾರ್ಯದರ್ಶಿ this is an order. This is an order. This is an order.
Yes, it's an order.
Passed under which provision?
No provision. There is no such power. Minister cannot keep giving orders like this from time to time, because what he says is, because these are the things which I am required to inquire under section 64, don't register the sites. Ultimately, if it is a dispute, interstate dispute between the members, if somebody's seniority is overlooked or not overlooked, that's a dispute which will be resolved under section 70 when it goes before the very same office. Something more than what the eye needs. We will take your lots to hear orders. The very same officer. Page 30 is the reason.
ಅಲ್ಲ, ಕಲಂ 64ರ ವಿಚಾರಣಾ ವರದಿ ಸ್ವೀಕೃತವಾಗಿ ಸತ್ಯಾಸತ್ಯತೆಯು ಕಂಡು ಬರುವವರೆಗೂ ಅಥವಾ ಸಂಘದ ಹಿರಿಯ ಸದಸ್ಯರು ನಿವೇಶನ ಠೇವಣಿ ಪಾವತಿಸಿ ನೋಂದಣಿಗೆ ಬಾಕಿ ಇರುವ ಸದಸ್ಯರಿಗೆ ಇಲಾಖೆಯಿಂದ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಗೆ ಅನುಮೋದನೆ ಪಡೆಯುವವರೆಗೂ.
He directs, don't allot any sites. I can understand, because all sites in dispute between the available. Not to register. Not to register is for those persons who have been allotted with the sites in 92 to 95, 2002, 2002 second stage, 2006, 2007 seventh stage, third stage.
Why it was not registered for all these years?
For these 4 years, what happened in previous 4 years, allotments were being made from time to time. Once the society had acquired this property, there were various civil disputes started. Then the non-planning authority which had granted the plan, so we had to get their consent for the release of the sites.
Yes.
We faced difficulty because the places where the disputes were arising, were either coming within that CA zone or park zone, all these adjustments were there. But still we made that adjustments, added the additional lands and thereafter we have distributed the sites. No member has a grievance. Members are not having any grievance, not even a single member has gone before the section 70 dispute and said that his seniority overlooked and one site is allotted. That is certainly permissible. It's a dispute which can be raised only by a member. If at all his seniority is overlooked. Because if a member seniority is overlooked, he may feel, no, I don't want to say. It's up to him.
You are aggrieved by this
It's not to
annexure
register.
annexure G.
Not to register ಅಂತ ಈಗ ಅವ್ರು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿಸಲ್ಲ ಅಂತಂದ್ರೆ ಅವ್ರ ಖಾತೆ ಆಗೋದಿಲ್ಲ ಅವರೆಲ್ಲ ಇವಾಗ ಬ್ಯಾಂಕ್ ಲೋನ್ಸ್ ಎಲ್ಲ ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡಿ ಇಟ್ಕೊಂಡಿರ್ತಾರೆ ಮೆಂಬರ್ಸ್ ಅವ್ರಿಗೆ ಮನೆ ಕಟ್ಟಕ್ಕಾಗಲ್ಲ ಇವಾಗ ನಮ್ದು 3 ಬಡಾವಣೆ they have constructed more than about 4,500 houses. ಯಾರ್ಯಾರಿಗೆ ಡಿಲೇ ಆಯಿತು ಈ ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಇದ್ದಿದ್ದರಿಂದ ಒಂದು ಕೆಲವೊಂದೊಳಗೆ 192A proceedings were pending because they alleged that it was a granted land, the grant was so and so. All these proceedings are clear, but still it is pending for about 267 sites so far as first stage is concerned. There we are not allotting to anyone. Disputes are pending. We are only registering the site to the people who have been allotted into the properties prior to 2018. Therefore, I gave that memo members. In this memo, your lordships will find in that first stage layout, 175 savings are yet to be registered for those persons to whom the sites are allotted prior to 2018. And layout 2, second stage layout, we have no problem. Third stage, another 19 sites are to be allotted for those persons who are given in 2006-2007. Kindly have a look at section 64, the powers under section 64. Shall have the following powers.
Yes.
We shall have at all times, the registrar or the person authorized by him under subsection 1 shall have, for the purpose of an inquiry under this section, shall have the following purpose. He shall at all times have the access to the books of accounts, documents, securities, cash, and other properties belonging to the custody of the society. May summon any person in possession or responsibility of the custody of any books, accounts, documents, securities, cash, or properties to produce the same at the public office at the headquarters of the society. Enquiry officer may also summon any officer of the financing bank, credit agency, as the case may be, or any person having any kind of business relationship with the society or any person who is connected with the functioning of and has knowledge about the efforts of the society to produce any records or documents, if any relate to the transactions with the working of the society, and furnish such information and explanations at the registered office and branch office or at any public office at the headquarters of the society. C1 and C2 will be material notes. He may, notwithstanding any rule or bylaw specifying the period of notice for the general meeting of the society, require the office bearers of the society to call a general meeting at such time, place at the headquarters of the society or any branch thereof, or to define such matters as to be directed by him. And where the office bearers of the society refuse or fail to call such a meeting, he shall have the power to call for it by himself. Any meeting called under clause 1 shall have the powers of the general meeting called under the bylaws of the society, and its proceedings shall be regulated by such bylaws, except that no quorum shall be necessary for the meeting. Then, what is the consequence? When an inquiry is made under this section, the registrar shall send the copy of the inquiry report and communicate the result of the inquiry to the society and to the cooperative society, if any, to which the society is affiliated, and also to the director of cooperative. Subsection 5. If the result of the inquiry head under subsection 1 discloses any defects in the working of the society, society shall within 45 days from the date of receipt of the inquiry report and communication of the result of the inquiry explain to the registrar the defects of the irregularities pointed out in the inquiry, take steps to rectify the defects and remedy the irregularities and report them to the registrar, the action taken by it thereon. The registrar may also make an order directing the society or its office bearers to take such action as may be specified in the order to remedy the defects within such as may be specified. Then section 68. The registrar shall make an order directing the cooperative society or its office bearers to take such action as may be specified in the order within the time mentioned therein to rectify the defects and remedy the irregularities disclosed in the audit report under section 63, inquiry under section 64 or inspection under section 65. The sine qua non for giving directions is the conclusion of the inquiry. In the conclusion of the inquiry, his powers is restricted to summon for the documents and to call for the general body. So, not to register the sites, to the society, is something which is far-reaching and overreaching the powers as such. A member should come to him and tell that, look, this is the problem with the society. The society has more with my seniority. I am raising a dispute. So and so is allotted. But this cannot be done on a large scale basis or just like a suo motu proceedings undertaken. Because society, once there are members of the society, the registrar cannot exercise the powers when a specific remedy is as well available to the member to avail of.
Yes, madam, what do you say?
Unless an entry that is finalized, inquiry, registration is going to be done by the society. You don't follow it is. You don't follow it is me and the making a statement, we are not making it, we are not given a single meeting after 17/3/2024. And making a statement before this report, we are not going to make any other.
Allah, registration kuda, if the allotment has been made,
Allotments are made.
not taking into consideration the seniority.
Challenge this, whatever allotments are made is
Ah.
subject to challenge before any authority.
Then how is it that this inquiry under section 64 commenced?
My inquiry under section 64 commences is because the persons who stood for the elections and who did not succeed in the elections in an earlier instance, they gave the complaint earlier to the present board coming into existence. This very officer started passing orders saying that don't make allotments, vacate the order. Don't make allotments, vacate the order. Very same officer. Kindly have a look at Annexure C series.
You said you had approached this court earlier.
Earlier it's against section 65 proceedings. That is state. Section 65 is again against the same allegations, with the same allegations. What is contained in section 64 is the allegations contained in section 65. Because I can understand. There should be a reasonable time within which the powers can be exercised because there is no time limit prescribed under section 64. First scenario is 6 years. Now we have made the 2016, 17. Members themselves are not agreed. Why the registrar should be agreed for all or the sites for members? Members should come and say we want. It should be fed to the members who be crying for it. Section 64 interim orders product. You can conclude the input, thereafter you can take a decision.
Complaint received by some of the members of the society.
Yes.
Said, section 64 is only an inquiry power. It is not an adjudicating power where interim orders should be done. Remember, I read that. Not just an amendment to more consent. It will be covered by the judgment in that event, you know, side. That's a judgment covering this.
Challenge is dated 10/4/2020. Already agreements are active. It may be adjourned weeks that the matter itself can be disposed.
The only point is, I am not arguing on the merits of the matter. Jurisdiction issue. They have a jurisdiction, they have jurisdiction. More jurisdiction would be. They distinctly remember. Because God's have this matter tomorrow. Is that?
Learned senior counsel, Sri D.R. Ravi Shankar, further submits that the impugned order dated 10/4/2023 at Annexure G is in the nature of an interim order directing the society not to register sale deeds in favor of the allottees. So, learned senior counsel submits that this court has held in one of its judgments that in a proceedings in an inquiry conducted under section 64, no such interim orders to be passed by the inquiring authority. Learned senior counsel seeks for a short adjournment to place on record the said decision. Full stop. Next, release this matter tomorrow.
Those matter. Number 8.
Yes.
The order passed by Eviction. My question was that the appellate authority granted the stay afterwards again. In number.
ಯಾವುದು?
Section B in the order.
Huh?
B. Yes, and ನಮ್ಮ neighbor without license, without any 6 floor ಕಟ್ತಾ ಇದ್ದಾರೆ. We made a complaint. ನಮ್ಮ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ eviction ಗೆ ಆರ್ಡರ್ ಇದೆ. ಆಕ್ಷನ್ ತಗೊಳ್ಬೇಕಾದ್ರೆ ಅವನು ಅಪೀಲ್ ಹೋದ. ಅಪೀಲ್ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 59. For 23, appellate authority passed this order.
ಯಾವುದು?
Number 59.
ಹಾ?
Page number 59.
59.
Case called advocate for appellant absent. Appellant present. The advocate case for impleading applicant is present. The impleading application is produced in appeal on the demolition order. It is the BBM authorities to determine the nature of the violation and the complaint is a necessary party after the complaint is made. Hence, the impleading application is disallowed. A reason put along but disallowed.
ಅದು ಆಕ್ಚುಲಿ is unnecessary ಅಂತ ಬರಬೇಕಾಗಿತ್ತು, necessary ಅಂತ ಬಂದ್ಬಿಟ್ಟಿದೆ.
Anyhow,
Yes.
the appellant request for a date, the counsel for appellant is in this world. He also files application for continuation stay. The application for stay is rejected. The case is to be finally heard on 29/4. A rejection ಮಾಡಿದ್ರು stay ಆ ದಿನ. Stay was not granted. Application for stay rejected. Next 29/4 ಗೆ ನನ್ನನ್ನು ಹೊರಗೆ ಹಾಕಿದ್ಮೇಲೆ impleading 29/4 ಗೆ ಮತ್ತೆ stay. Complaint.
There has to be a stay. How can the chief commissioner permit the engineer to go and demolish the building when the appeal itself is not considered?
Decide ಆಗಲ್ಲ appeal. ಎಷ್ಟು ವರ್ಷ ಆದ್ರೂ.
So
no, I am a complainant, I am a necessary party.
ಇರಬಹುದು ಸರ್. You are aggrieved of what now?
Now I am challenged not second order, first order, not impleading me.
Rejecting your application for impleadment.
ಅದನ್ನ challenge ಮಾಡಿದ್ದೀನಿ. I am a necessary party, I should be given. I will also place request before the appellate.
What interim order can be passed in this matter?
ಅಲ್ಲ ಇಂಟೀರಿಯರ್ ಮಾಡಿದ್ರೆ ಹಳೆ ಕೇಸ್ ನಲ್ಲಿ ಇಂಟೀರಿಯರ್ ಮಾಡಿದ್ರು ಏನಿಲ್ಲ 6 ಫ್ಲೋರ್ ಕಟ್ತಾ ಇದ್ದಾನೆ ಈಗ.
ಅಲ್ಲ ಸರಿ ಸರ್, ಏನ್ interim order ಪಾಸ್ ಮಾಡಬಹುದು ಇದರಲ್ಲಿ? Why this submission was not made by your colleague in the morning? I would have issued notice. Why did you ask the matter to be passed over? Agli sir, you should encourage your colleagues. You should say there is no interim order. You kindly issue notice. You would have done it. Why do you get the matters passed over like this? Learned Counsel Sri Pawan Kumar, who is present in the court, takes notice for response number 1 to 4. BWSSG ಅನ್ನಕ್ಕೆ
ಅದು ಆ ವಾಟರ್ ಕನೆಕ್ಷನ್ ಇದು ತಗೊಳ್ತಾರೆ.
ಏನ್ ಸರ್ you I don't know. See, you should understand the limits of a complainant. It is not as if there is a dispute between the parties claiming rights over the property. ಇದು ಹಂಗಲ್ಲ ಇದು.
ಅಲ್ಲ ಮೊದಲ ರಿಟ್ ನಲ್ಲಿ ಇದ್ರು ಅದಕ್ಕೆ ಹಾಗೆ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ. ಲಾಸ್ಟ್ ಮೇ I don't have objection to leave R5. R6 to R9
Issue emergent notice to response number 6 to 9.
6 to 9 I am permitted to take out notice to the council who is represented.
apart from paying for to process.
The petitioner is also permitted to serve a copy of the writ petition along with annexures on learned counsel.
Appeared for 6 to 9. 6 to 9.
ಯಾರದು?
ಅಲ್ಲಿ ಶಶಾಂಕ್ ಆರ್ ಅನ್ನೋರು appeared. ಶರತ್ ಎನ್ advocate.
ಅವರು
ಅವರಿಗೆ
ಶರತ್ ಎನ್
ಹಾ.
ರೆಸ್ಪಾನ್ಸ್ ನಂಬರ್ 1 to 4.
6 to 9.
Learned counsel Shri N. Sharath, who appeared for the contesting respondents in the earlier writ petition. Notice to respond number 5 is dispensed with. So, learned counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned counsel for the respondent DPM. Yes.
ROG.
File a memo and
Huh?
file a memo and
What?
next week we'll have that file ಮಾಡಿ.
The request of learned counsel for petitioner released this matter on 24th of July, Monday.
Number 1. Right now, ready.
ಅಲ್ಲ ನೋಡೋಣ, ಇದು ಮುಗಿದ್ಮೇಲೆ ಬರ್ತೀವಿ ಈಗ. ಕಮ್ ಬ್ಯಾಕ್. These are all election matters.
Kodambahalli village, that is not the present term, but the second term it is notified for a general.
ಕೊಡಮ್ಮ ಚೆಕ್ ಲಿಸ್ಟ್. ಹಾ ಮಾಡಿದಾರಾ? ಯಾವ್ದು ಗ್ರಾಮ ಪಂಚಾಯತ್?
Kodambahalli.
ಸೀರಿಯಲ್ ನಂಬರ್
In 2800 in my page.
ಉಡಂಬಳ್ಳಿ.
My petition page 18.
ಉಡಂಬಳ್ಳಿ ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದಾರೆ ಸರಿ?
There is general woman.
ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್
Vice President is supposed to be the candidate.
ರಿವರ್ಸ್ ಮಾಡಿದ್ದಾರೆ. What is your contention?
I guess we can go to the since from 19. The SC woman is not given. The SC one time is repeated, that is in 2005. But other franchise is concerned, more than 2 times this. What is the report of president?
You please see that list.
Yes.
The checklist ಅಲ್ಲಿ on the same page where you find this Kodamballi.
Yes.
Serial number 21 ನೋಡಿ.
Yes.
ಪೊಂಗನೂರು
Yes.
SC 4, ನೀಲಸಂದ್ರ SC 5, ತಕ್ಷಗೆರೆ SC 7, ಬಂದಾರಗುಪ್ಪೆ 5, ರಾಂಪುರ 5, ನಿಮ್ದು ಓನ್ಲಿ 1. ನ್ಯಾಚುರಲಿ ಅದಾಗೆ ಆಗುತ್ತೆ, ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. You have only 1 seat for SC.
Net population is not the concept.
Huh?
44 is census. The population of the overall. to determine-
Based on the population, the number of seats are reserved.
Yes.
For your Gram Panchayat, only 1 seat for SC is reserved. So therefore, going by the cycle and the total number of seats allocated to the other Gram Panchayats, which have got more number of SC seats,
Yes.
naturally there will be repetition for them.
That means the constituency based on the population of determining the seats of scheduled caste to the post of president. This is something completely different. It is not how many seats they are provided.
Correct. Once that is determined,
Yes.
the deputy commissioner can only follow What has already been assigned. ಇವಾಗ ಒಂದು ಗ್ರಾಮ ಪಂಚಾಯತ್ಗೆ 7 ಶೆಡ್ಯೂಲ್ ಕಾಸ್ಟ್ ಸೀಟ್ಸ್. What is the total number of SC seats in the taluk? 6. So you can imagine. In one term, only 6 seats can be reserved. In one term, in one cycle, in one term. Adadmele next, they have to find out which is the next highest gram panchayat which have the population of SC.
That is not the way which has been done.
That is the way. That is the way. That is the guidelines.
Not in guidelines is in the consultation. with the
Are you challenging the guidelines?
One of the matter I heard that the guidelines are.
ಅಲ್ಲ ಈ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ಬಿಡಿ. ಎಸ್ ಮೇಡಮ್.
Lottery is the problem. Lottery how.
ಅಲ್ಲ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಸಿ ಅದರ್ವೈಸ್ how to decide when there are more than one gram panchayat which stand on the same footing? How do you decide?
Here Miller, instead of lottery, other methods are.
ಏನ್ ಮೆಥಡ್? ಏನ್ ಮೆಥಡ್?
This lottery is very non-transparent.
No. It is the most transparent way.
As good as Miller find out behind the control.
No. That lottery will not be just made use of at any point of time. Angalla ado. Only in certain circumstances where more than one gram panchayat becomes eligible for allotment of a particular reservation. When there are more than one number, then how to decide? Only in those circumstances, a system of lottery is provided. It is not that it can be made use of any time.
Here is the case.
So they have given the worksheet.
Yes.
According to that, ಪರಿಶಿಷ್ಟ ಜಾತಿಗೆ 6 ಮೀಸಲಾತಿ ಸ್ಥಾನಗಳನ್ನು ಆಯ್ಕೆ ಮಾಡಬೇಕಾಗಿತ್ತು. ಜಿಪಿಪಿ ಅಪ್ಲಿಕೇಶನ್ ಮುಖಾಂತರ ಮೀಸಲಾತಿ ಪ್ರಕ್ರಿಯೆ ನಡೆಸಲಾಗಿ ಸದರಿ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಈ ಕೆಳಕಂಡ ಪಂಚಾಯಿತಿಗಳು ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ಆರಿಸಿ ಬಂದಿರುತ್ತವೆ. ಇನ್ ದಿ ಅಪ್ಲಿಕೇಶನ್ ಇಟ್ ಸೆಲ್ಫ್, ಇಟ್ಸ್ ಎ ಕಂಪ್ಯೂಟರೈಸ್ಡ್ ಪ್ರೋಸೆಸ್. ದಿ ನಂಬರ್ ಆಫ್ ಪಾಪ್ಯುಲೇಷನ್ according to which the seats are reserved and which were the gram panchayats given SC reservation previous term, adanella consider ಮಾಡಿ 8 gram panchayats become directly eligible for allotment of 6 seats. ಈಗ out of this 8, how to fix ಅನ್ನೋದು. ಮೇಲ್ಕಂಡ 4 ಗ್ರಾಮ ಪಂಚಾಯತಿಗಳು ಇಲ್ಲಿ ಡೈರೆಕ್ಟ್ ಆಗಿ ಅಕ್ಕೂರು, ಭೂಹಳ್ಳಿ, ಮೈಲನಾಯಕನಹಳ್ಳಿ, ವಿವಿ ಹಳ್ಳಿ ಇನ್ನೇನ್ ಟೈಮ್ ಇಲ್ಲ.
I'll just go through this. This lottery is concerned and they are considering these 8 panchayats to determine 6.
8 panchayats are standing on the same footing. Yes. That is why I have been saying in writ proceedings, not only in these matters, administrative law, the principles governing administrative law is that the High Court, which is entrusted with the power under Article 226 of the Constitution, is required to find out whether the authorities are doing their acts or passing orders in accordance with the provisions of law, the rules, norms. If that much is satisfied, the result is not so much of a interest to the courts. We are only required to find out whether the procedures contemplated are followed. If that is followed, that will satisfy the requirement of law. Therefore, if the worksheet provided by the deputy commissioner shows the scrupulous manner in which the process has been done, then there is no cause for interference. If you are saying the lottery system is not correct, then you should have challenged the guidelines itself. Again, you'll have to list this matter tomorrow. Huh?
Cannot take more than one.
But again, it has to be listed, sir, tomorrow for that purpose. Yalla urgency antira. When the matter comes up,
This is just I now received.
although that is not supposed to be given to you.
Yes. This will not at least.
Because I was reading it out, the learned AAG gave you a copy yesterday. It is not necessary that it has to be given to you.
At least they would have been published.
Madak barodilla.
At least how they have worked out. This will
No, no, no.
not for- It is for the citizen, really would not have published it.
The entire process is video recorded. All this process is video recorded,
I'm not saying that.
and these are the minutes that are recorded. Yesterday.
I'm not saying that non-trans, saying that, Caesar is concerned. Exactly.
At the request of the learned counsel for petitioner, release this matter tomorrow. First time ಬಂದಿರೋದಾ ಇದು learned HCGP takes notice. To 3. Learned counsel Srimati Vaishali Agde is requested to take notice for respond number 5. Notice to respond number 4 is dispensed with. Learned counsel for petitioner is requested to serve 2 sets of copies of the petition along with annexures on learned counsel for respond number 5 and a copy on the learned HCGP. Full stop. Next para. ಅದನ್ನ ಹಾಕೊಂಡು ಅಲ್ಲಿ ಹಾಕೊಳ್ಳಿ.
Reservation is not allowed in this part. Court ground, right? It is a-
Since you have made all these Gram Panchayats a party, we will issue notice. Let it go and come.
Discrepancies, they are met. Respondent number 4 to 45 dispense.
You know, you are anticipating that if an order is passed, it would affect the other Gram Panchayats. So therefore, you have implemented all of them. Let notice go and come. Let them all come. We'll see. Huh? Learned HCGP takes notice for response number 1 and 2. Learned counsel Srimati Vaishali Agde is requested to take notice. Is dispensed with for the time being. Stop. Learned counsel for petitioner is directed to serve 2 sets of copies of the petition along with annexures on learned counsel for respond number 3 and a copy on the learned HCGP. Release this matter tomorrow.
Thing for the petitioner here, my lord. He is out of town due to health emergency.
Huh?
She has got out of town due to health emergency. Any date next week could be done.
at the request of learned counsel for petitioner, release this matter on 26th of July.
The interim order granted.
Interim order granted earlier stands extended till next date of hearing.
Number 4, Shivaram.
This is where we had issued direction. ಏನಾಯ್ತು?
The direction, honorable court, my lord.
Hmm.
The deputy commissioner writes to the election commission, para 3 members. To election commission that we have been directed by the court that we need to revert the
Yes.
reservation. Then election commission sends us the communication, my lord, dated 15/7/2023. Election R2, my lord, kindly take. Page 5, my lord. Last paragraph. ಆದುದರಿಂದ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಆನೇಕಲ್ ತಾಲೂಕಿಗೆ 2ನೇ ಅವಧಿಯ ಗ್ರಾಮ ಪಂಚಾಯತಿಗಳ ಅಧ್ಯಕ್ಷ ಉಪಾಧ್ಯಕ್ಷರ ಹುದ್ದೆಗೆ ಮೀಸಲಾಗಿದೆ. ಆಯೋಗದ ಉಲ್ಲೇಖದ ಮಾರ್ಗಸೂಚಿಯಂತೆ ನಿಗದಿಪಡಿಸಿರುವ ಬಗ್ಗೆ ಮತ್ತೊಮ್ಮೆ ಖಾತ್ರಿಪಡಿಸಿಕೊಂಡು ಸೂಕ್ತ ಸಮರ್ಥನೆಯೊಂದಿಗೆ ನಡವಳಿ ತಯಾರಿಸಿ ದಿನಾಂಕ 19/7/23ರಂದು ನ್ಯಾಯಾಲಯದ ಆದೇಶಕ್ಕೆ ತರುವಂತೆ ಈ ಮೂಲಕ ತಮಗೆ the guidelines and explanation as to each election, you make the proceedings of that. Connection R3 is the proceedings. The details again in the GPUC software numbers, and now again similar reservations have come up. Page 15. My lord, from beginning, the detailed proceedings drawn lecture R3.
Allah, if the same thing is repeated, then as we have pointed out, that then there may be something required to. If the software is not made sensitive to certain other factors, as was noticed, so without making the changes, if you feed the information, same results will come.
We requested the election commission review of these directions. We were asked about read out.
Verify ಮಾಡಿ ಮೊದಲಿನ ಮತ್ತೆ ಕರೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಇದು ಮಾಡಿದ್ವಿ ಅಂತ ಮಿಸ್ಟೇಕ್ ಇತ್ತು ಅದನ್ನ ಕರೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಕೊಟ್ಟಿದ್ವಿ.
Allah, see from the checklist, you please point out on checklist worksheet it. From the worksheet, now all the that minutes that are recorded. Is there anything made to bring out certain factors which were pointed out by this court? And if you say there is no such provision, then we'll have to direct to do it manually. Yes, Mr. ಏನಾಗಿದೆ, I don't know whether you were present in the previous date of hearing. ಎಲ್ಲೆಲ್ಲಿ GM ಬರೀ ಅದೇ ಬರ್ತಾ ಇದೆ. ಇನ್ನು ಕೆಲವಕ್ಕೆ GM ಫಿಮೇಲ್ ಅಲ್ಲ ಅದೆಲ್ಲ ಆಯ್ತು. ಸಿ ಆಲ್ ದಟ್ ಇಸ್ ಅಕ್ಸೆಪ್ಟಬಲ್. ಈಗ ನೋ ಲಾಸ್ಟ್ ಬಂದಾಗ ವೆನ್ ಯು ಕಮ್ ಟು allocation of the general seats, no doubt you have issued guidelines stating that from amongst the remaining gram panchayat, you will have to first identify for which GM female has to be given. No doubt he has followed all that procedure, but what we are trying to say is that the system has to be made sensitive towards certain other factors. It also has to take into consideration all the previous reservations that were made. If it is found that earlier on more than one occasion GM female was given, then it should take that into consideration and give GM this time. If this factor is not put into the application, then naturally it will give out the same results.
There is women are concerned. I have to give for every category horizontal reservation.
ಅದೆಲ್ಲ ಆಗೋಯ್ತು. We have come to the end now.
End ಅಲ್ಲಿ woman this constituency, my constituency gets GM women suppose I got it in 2015.
ಬರೀ ಒಂದೇ ಅಲ್ಲ, 2015 ಅಲ್ಲ, ಅಲ್ಲ ಕಂಟಿನ್ಯೂಸ್ ಆಗಿ 3-4 ಸರಿ ಏನ್ GM ಬಂದಿದೆ. ಎವ್ರಿ ಟೈಮ್ ಇಟ್ ಇಸ್ GM ಫಿಮೇಲ್ ಓನ್ಲಿ. Therefore, what we are trying to tell is that this is something, a factor that has to be incorporated into the application. Yes.
Then we still work out what you want. Allow the election commission to. They work out.
ಇಲ್ಲ, ಇವಾಗ ಸದ್ಯಕ್ಕೆ ಏನು ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ. You have to allow the deputy commissioner to do it manually, only the last part of it.
Manually, in fact, the election commission also has worked out.
Yes.
They have worked out. But it's coming the same thing. What is the difficulty is because immediate previous term women put in avoid money so that they don't get generally succeeding women who study. There are about 14 seats which I have to give for the women. In 28 gram panchayats. In SC Malad, almost 11 gram panchayats have got 3 times over. In the 10th term, in 9 terms, 3 times, SC has rotated for all about 11 gram panchayats. All women. Up to 2010, backward class A and B also were getting reservation. After 2010, it's deleted. They don't get backward class.
ಅಲ್ಲ ಅದನ್ನು that is another aspect of it, challenge of this is we will come to that.
Because women are treated everywhere. As far as possible, we are told them try as far as possible not to give or ensure that women is not repeated. But generally when they are doing this exercise, general women first general women fix ಮಾಡುವಾಗ they will see the previous term whether women ಯಾವ್ದಾರ category ಕೊಟ್ಟಿದ್ರು ಇಲ್ಲ ಅಂದ್ರೆ ಅವಾಯ್ಡ್ ಮಾಡಿ. What happens? They have to check SC women, ST women, everyone, and then calculate whatever is remaining. Generally, I have to give. I will still ask the election commission itself to work out manually to see. Apart from the software is feeding the data.
Correct.
Nothing else.
Correct.
That is to ensure that there is no discrimination. We brought in that system.
When he puts it to election commission, and the next one may notice serial number 13 and 14 in my list. ನಾನು ಕೊಟ್ಟ ಲಿಸ್ಟ್ ಆ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 13 and 14 ಅದಕ್ಕೆ ಇಲ್ಲಿವರೆಗೆ ಜನರಲ್ ಫಿಮೇಲ್ ಬಂದಿದೆ. ಇವೆರಡಕ್ಕೂ ಮಂಟಪ ಅಂಡ್ ಬನ್ನೇರುಘಟ್ಟ. ಆಮೇಲೆ ಇದೆಲ್ಲ ಕಡೆ 2 ಸಲ 3ನೇ ಸಲ ಬಂದಿದೆ. ಉಳಿದವೆಲ್ಲ ಒಂದೊಂದೇ ಇದ್ದವು ಇದಾವೆ. ಹಾಗೆ 3ನೇ ಸಲ ಬಂದಿದೆ.
But the lordship takes
Ultimately,
checklist and no, I understand. But if the lordship takes this checklist, which is the checklist put it there.
Yes.
And serial number 14, mandapa problem is no.
ಅದೇ ಪ್ರೀವಿಯಸ್ ಟರ್ಮ್ ಅಲ್ಲಿ SC ಫೀಮೇಲ್ ಅದೇ ಅದೇ ಸೊ
general woman put again somebody will complete. At least general everyone will have a chance to contest. Then my lord, previously they have got some other woman was there, SC woman ಹೋಗಿದೆ ಒಂದ್ಸತಿ category A female ಹೋಗಿದೆ, SC female ಹೋಗಿದೆ. So 3 times some given has got. But this time the problem is the section says first not SC, then the ST, then come down to general. By that time if it takes the female, the problem is.
ಅದನ್ನ ಮಾಡೋದಕ್ಕೆ ಹೋದ್ರೆ ಇವಕ್ಕೆ ಇಲ್ಲಿವರೆಗೂ ಜನರಲ್ ಫೀಮೇಲ್ ರೀಚೇ ಆಗೋದಿಲ್ಲ. Without reaching close to villages, there will be limitation.
This is complex thing. I understand general female, at least the female has a chance to contest in general. Nobody is right.
Rotation. ಈಗ ಅಲ್ಲಿಗೆ ರೀಚ್ ಆಗದಂಗೆ ಬೇರೆ ಕಡೆ ರಿಪೀಟ್ ಆದ್ರೆ ನಾಟ್ ರೊಟೇಷನ್. ಅವೆರಡಕ್ಕೂ ಇಲ್ಲಿವರೆಗೆ ಸುಮಾರು ಈಗ 5 ಇಲೆಕ್ಷನ್ ಆದವು. 5 ಇಲೆಕ್ಷನ್ ನಲ್ಲಿ ಜನರಲ್ ಫೀಮೇಲ್ ಆಫೀಸ್ ಬ್ಯಾರಲ್ 15 ಅಷ್ಟಕ್ಕೂ ಇಲ್ಲಿವರೆಗೂ ಒಮ್ಮೆ ಅಲ್ಲಿಗೆ ರೀಚ್ ಆಗದೆ ಹೋದ್ರೆ ರಿಪೀಟೇಷನ್ ಆಗುತ್ತೆ.
SC is getting repeated twice. But 9 terms, there are only 28 gram panchayats. So 13 seats keep going, and one SC is always not the female. Because there is only one SC. So 14, 6 and 7 members will occupy here.
ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಮರಸಾರು ಅಲ್ಲಿ ಇಲ್ಲಿವರೆಗೆ 4 ಜನರಲ್ ಬಂದಿದೆ. ಈ ಸಲಕ್ಕೂ ಕೊಟ್ಟಿದ್ದೀನಿ 5 ಜನರಲ್. ಅಂದ್ರೆ
General I can still ask them to. I can come back tomorrow also. SC, ST Miller, they have to find out the problem. Because unless I fit SC, ST Miller, then I can't do it.
ಅದೇ ಕರ್ಪೂರ ಅಂಡ್ ಮರಸಾರು ನೋಡಿ ರಿಪೀಟ್ ಆಗಿದೆ, ಜನರಲ್ ಹೆಚ್ಚಿಗೆ ಬಂದಿದೆ. There can be some adjustments.
What I do is all the elections manually ಅವರೇ work. But they had worked out manually ಬಂದು they showed get the software, but we work out on our own. It will be any result that's and still call them to I will try it. Still pointed out that as far as possible we'll see what the best. But
ಆವಾಗ we cannot say that this guideline ನಲ್ಲಿ ನಾವು ಇದನ್ನು ಪ್ರಿಸ್ಕ್ರೈಬ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದೇವೆ, ಅದಕ್ಕಾಗಿ rotation will affect ಅಂತ ಹೇಳೋದು. ಯಾಕಂದ್ರೆ rotation is constitutional requirement. Guidelines into it is for the purpose of working. Guidelines cannot take a precedence.
Rotation has taken place. CST rotation. General should be horizontal reservation for general women. Unless I do that for the 13 seats, I have to, if your lordship says 9 term of 3 times it's repeated. I can't do anything. SC ಜಾಸ್ತಿ ಇದಾವೆ. Also same thing.
ಅಲ್ಲ ಇವಾಗ
I think some
because your lordships are indicating whether any problem is there in the manually ensure that the undersecretary
28 ಗ್ರಾಮ ಪಂಚಾಯತ್ಸ್ ಅಲ್ಲಿ SC ಎಷ್ಟು
13 then 7 are reserved for women.
ST
is only one gets automatically reserved for. A and B 0. 14 is general, in which 6 are reserved for women.
learned additional advocate has filed an affidavit of the election Tahsildar, Bangalore urban district, along with certain other documents. So, learned AAG submits that in terms of the directions given by this court, the deputy commissioner cum election officer wrote to the election commission bringing to its notice the directions issued by this court. Stop. The election commission wrote back to the deputy commissioner that he shall redo the entire exercise having regard to the observations made by this court and scrupulously following the guidelines. Full stop. Consequently, the entire exercise was redone and the end result is the same as per the impugned notification. Stop. All the information is made available along with the affidavit. Stop. Copy of the same is served on the learned counsel for petitioners. Stop. Next para. However, learned senior counsel Sri Jaikumar S. Patil, appearing for the petitioners, submitted that if the information is fed to the computer application, computer system with the same application, then naturally the same results would come out. Stop. Learned senior counsel Sri K.N. Panindra, appearing for the State Election Commission, submits that he too has discussed the matter with the Election Commission. Stop. The learned senior counsel would submit that since this court has pointed out that if the relevant factors are not fed into the system and a re-exercise is done with the same information, there cannot be any change. Therefore, the learned senior counsel would submit that the matter may be taken up tomorrow, so that he would discuss the matter once again with the Election Commission and try to work out the try to redo the exercise manually, taking into consideration the observations made by this court and the relevant factors. Full stop. Next para. Release this matter on 20th of July at 2:30. These matters already connected. Connect ಆಗಿದೆ. ಆನೇಕಲ್ದು ಎಲ್ಲ ಕನೆಕ್ಟ್ ಆಗಿದೆ. That is why we said we can't find any fault with them. But the problem is the system has to be fed with the relevant factors. That is what has been canvassed. Let us see how we can do this. This number 1. There, Saukar.
Number 47.
Number 2, cell number 47.
Appear for the petitioner. I have served the copy on the other side.
Yes, yes.
In fact, for the last more than 25 years, the reservation for the post of the president, SC is not been, but all other categories have been 2-3 times they have come up there. Candidate annexure B at page 11. SC male is not been considered for the last.
ಯಾವ ಗ್ರಾಮ ಪಂಚಾಯತ್?
ಇದು
ಯಾವ ಗ್ರಾಮ ಪಂಚಾಯತ್?
ಬಳ್ಳಿಗನೂರು ಗ್ರಾಮ ಪಂಚಾಯತ್. ಬಳ್ಳಿಗನೂರು.
ಸೀರಿಯಲ್ ನಂಬರ್ 8. ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದಾರೆ ಈ ಸರಿ?
ಈ ಸರಿ ಇದು ಕೊಟ್ಟಿದ್ದಾರೆ BCMA ಫಾರ್ ದಿ ಸೆಕೆಂಡ್ ಹಾಫ್.
ಕ್ಯಾಟಗರಿ ಎ.
ಎಸ್,
ಕ್ಯಾಟಗರಿ ಎ. ಆಮೇಲೆ ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್
ಪರಿಶಿಷ್ಟ ಜಾತಿ ಮಹಿಳೆ ಅಂತ ಕೊಡ್ತಾರೆ.
SC ಫೀಮೇಲ್.
ಎಸ್ ಮ್ಯಾಮ್. Right from the beginning, 1993 onwards. This
93 ಅಲ್ಲೇ ಬಂದಿತ್ತಲ್ಲ SC.
ಆಮೇಲೆ ಬಂದ ಇಲ್ಲ for the last so many, but other categories have been.
2015 ಅಲ್ಲಿ SC ಫೀಮೇಲ್ ಬಂದಿದೆ. ಎಷ್ಟು? 60. 60ರಲ್ಲಿ eight.
My lord, they've already got moved down.
Please, madam.
There are 60 gram panchayats in your taluk. See, you have not given all this information, but anyhow, the learned AAG is prepared with the entire information. There are 60 gram panchayats in the taluk.
Please.
Only 8 reservation for SC. That 8 has to be rotated.
Please.
So, ನಿಮಗೆ SC ಫೀಮೇಲ್ 2015 ಅಲ್ಲಿ ಬಂದಿರೋದ್ರಿಂದ ನೀವು 8 into 5 ಟರ್ಮ್ಸ್ ಆಗ್ಬೇಕು, ಮತ್ತೆ ರಿಪೀಟ್ ಆಗ್ಬೇಕು ಅಂತಂದ್ರೆ ಇದು ಜಾಸ್ತಿನಾ? ಇನ್ನು ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಮೋರ್ ದೆನ್ 7 ಟೈಮ್ಸ್, ಮೋರ್ ದೆನ್ 7 ಟರ್ಮ್ಸ್ ಆಗ್ಬೇಕು, ಒಂದು ಸೈಕಲ್ ಕ್ಲಿಯರ್ ಆಗ್ಬೇಕು ಅಂತಂದ್ರೆ. ಸೊ ಸಿನ್ಸ್ 2015 ಅಲ್ಲಿ ಬಂದಿರೋದ್ರಿಂದ ಯು ವಿಲ್ ಹ್ಯಾವ್ ಟು ವೇಟ್ ಫಾರ್ another 5 terms. That is how the cycle would work.
Like the wrong factors have been fed into the system.
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಹಂಗ್ ಬರೋದಿಲ್ಲ. ಇದರಲ್ಲಿ as per the guidelines, first what has to be taken is the scheduled caste category. ಆ scheduled caste category ತಗೊಂಡಾಗ ಪ್ರೀವಿಯಸ್ ಟರ್ಮ್ ಅಲ್ಲಿ ಯಾವ್ದಕ್ಕೆ ಕೊಟ್ಟಿದ್ರು ಅಂತ ನೋಡ್ತಾರೆ. ಅದನ್ನ ಹೊರತುಪಡಿಸಿ then they will go to the next lowest number of
category
members who got the reservation of SC. ಆ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಡೈರೆಕ್ಟ್ ಆಗಿ ಕೊಡ್ಬೇಕು. ಅಂತ ಕೇಸಲ್ಲಿ if there are more than one gram panchayat which is standing on the same footing, then the system of lottery will be adopted. So ಇದನ್ನೆಲ್ಲ ಅವರು they have provided in the guidelines. I don't think
followed the procedural.
Yes, yes. Perfect. Petitioner who is a member of Baliganur Gram Panchayat, Kadur Taluk is aggrieved of notification impugn ಮಾಡಿಲ್ಲ ನೀವು.
ಇಲ್ಲ ಇದು ಅಷ್ಟೇ.
Is aggrieved of the fact that scheduled caste reservation is not given to the post of Adhyaksha of the Gram Panchayat. Stop. In this regard, a representation dated 30/6/2023 is given by the petitioner to the third respondent deputy commissioner come election officer. So the prayer in this writ petition is to direct the deputy commissioner to consider the representation given by the petitioner. Full stop. Next para. Learned additional advocate general, appearing on behalf of the respondent state and the deputy commissioner would submit that the exercise of identifying the reservation by rotation is already complete and a notification dated please get that information and give that information. Notification dated so and so has been published indicating the reservation in respect of the particular category in all the Gram Panchayats of Kadur Taluk. Stop. As per the notification 27/6/2023. As per the notification, the post of Adhyaksha of Baliganuru Gram Panchayat is reserved for category A and the post of Upadhyaksha is reserved for scheduled caste bracket female. Stop. Learned AG submits that Kadur Taluk has got 60 Gram Panchayats, out of which only 8 posts of Adhyaksha are reserved for scheduled caste category. Stop. In terms of the requirement of the guidelines, which are in the form of a government order dated 25/5/2023, the deputy commissioner is required to first identify the SC reservation given in the previous term. So, after excluding all the Gram Panchayats which had reservation of SC category in the immediate past term, the next set of 6 Gram Panchayats which become eligible in terms of the number of seats identified in the Gram Panchayat for SC reservation, which again is based on the population of the scheduled castes in the Gram Panchayat, reservation is required to be given to the next set of Gram Panchayats. Full stop. However, the entire exercise is now computerized and is done on the basis of GPP VP application. Stop. the information is fed into the system, identifies the next set of gram panchayats which become eligible for allotment of SC reservation. Stop. Learned AG submits that Pelliganuru Gram Panchayat had SC female reservation in the year 2015. Stop. Therefore, comma, having regard to the total number of Gram Panchayats, that is 60, comma, it will take more than 7 terms for repetition of the scheduled caste category to Balliganuru Gram Panchayat. Stop. In that view of the matter, comma, it is submitted that allocation of scheduled caste category reservation to Balliganuru Gram Panchayat cannot be expected even in terms of the guidelines issued by the State Election Commission. Full stop. Next para. Having regard to the submissions made by the learned AAG and the fact that the entire system has now been computerized, comma, this court finds that the respondent deputy commissioner has followed the guidelines and no fault can be found in the action of the respondent deputy commissioner in making the reservations in terms of the notification dated so and so. Full stop. Next para. For the reason stated above, the writ petition stands dismissed.
Constructed a building in the year 2009. I obtained the title plan. I obtained the sanction plan for ITBT because the property falls within the residential mixed area. The residential mixed area is even admitted by the BBMP in its additional statement of objection. My plot is about 240 square meters. The road is a 18 meter road. By virtue of that, in a residential mixed area, at that point in time, I could use the ancillary use as the main usage. So by virtue of that, I obtained a plan sanction. I constructed according to the plan sanction.
Mr. Pawan Kumar is appearing for BBMP.
On the last day. Given Dr. Ramchandran had filed objection. The objection is not.
Aggrieved by the impugn notice at annexure A.
Annexure A, page 20.
What is this notice?
Lord, the notice would say that in a residential area, I'm running a commercial activity. And within 3 days, if I don't take requisite action, it has to be action to be taken as per the DMC Act.
Yes.
My plan sanction is at annexure C, Lord. It may also, I think, be found at annexure M, Lord.
Yes.
Sanction 2009. It's sanctioned for ITBT.
Huh?
For IT, the BPO.
Residential, IT, BT, BPO.
Which falls under I2 category. Please to see the revised master plan.
So you have obtained a sanction plan
I
for.
obtained a sanction plan, everything is done.
What is the problem?
Based on another judgment, which is passed in the year 2002. When I passed that judgment. Based on this judgment, even on these notices.
That is a general order.
Yes, sir. This is,
It's a public interest litigation.
yes, Lord.
Ah.
And it's a subsequent order.
Ah,
Based on this, they issued these notices. By trying to retrospectively apply this judgment to me.
what does this judgment say?
Effectively, my lord, they had amended the revised master plan. The BDA. Relevant portion would be at page 14 of the order, my lord. Essentially, they would say that no commercial activity of any nature would be allowed even in residential mix. Even if it is allowed, it is only up to 20% in ring 1 and 2 or 50 square meters, whichever is lower. That is what they would change subsequent to that date. And there is an interim order in this matter from 2000.
You obtained the plan when? Which year? 2009.
August 2009.
That was sanctioned in accordance with the prevailing zoning regulation.
The law has been applied to me as per what it was at that point.
Yes.
In time. He would want to retrospectively apply it to me after I have constructed, after I have let it out, after I have utilized the property.
Yes, Mr. Pawan Kumar. It's all right, no difficulty. Please understand. The notice is issued as if he has not obtained a plan for putting up a commercial construction. That is not correct. You have yourself sanctioned the plan for putting up commercial construction. Therefore, merely because judgment or directions are issued in a public interest litigation. See, those directions were given to ensure that without obtaining a sanctioned plan in a residential area, in a purely residential area, if you are carrying on a commercial activity, it would become impermissible. Therefore, action was directed to be taken. But in the present case, in the year 2009 itself, he has obtained a sanctioned plan and accordingly has put up the construction. So therefore, this notice could not have been issued at all. Anyway, you could have given a reply.
Was the Lord respond number 3, who is the complainant. Who is the troublemaker in the area, Lord. Notices were issued to all the establishments in that area. There are 3-4 petitions that we have to file. One of them has been partly allowed, the other 2 more are pending. He now has to also please proceed with all this, Lord. He now wants to not pursue it anymore. All this itself indicates he does not want to pursue the case anymore. Also.
Permitting him to withdraw from appearing in the case and can be decided as per rules. Yes.
In fact, he was allowed to be impeded also, my lord. That's all. That was on a point which was also contrary to several judgments. But nonetheless, he joined. It was at his base that all of this has been happening. But despite my reply is also produced. Okay. Ultimately, the BBMP itself would file its.
And this is issued by the health officer. The notice is issued by the health officer. Trade license Allah. This is not regarding trade license. ITBP ge for establishing a ITBP office, you issue trade license. It is trade license ಬಗ್ಗೆ ಅಲ್ಲ. Correct. ಅಲ್ಲ ಕಮರ್ಷಿಯಲ್ ಆಕ್ಟಿವಿಟಿ ಅಂದ್ರೆ ಇವಾಗ they have been running ITBP office. ಅದಕ್ಕೆ There is no question of trade license for that. Perkal. The petitioner was visited with the impugned notice dated 28/12/2015 at Annexure A, issued by the second respondent health officer, Jayanagara subdivision, BBMP. Wherein it was alleged that complaints have been received stating that the petitioner has been utilizing the building in question for commercial purposes. So, it is stated in the notice that the area in question being a purely residential area, no commercial activity was permissible. It's all. Therefore, the petitioner was called upon to explain why action should not be taken in terms of the provisions of the Karnataka Municipal Corporations Act, 1976. It's all. Next para. Learned counsel for the petitioner submits that. Where is your reply? The petitioner caused a reply dated 4/1/2016, within a few days after receipt of the impugned notice. So, it was stated in the reply that the petitioner obtained a sanction plan dated 26/8/2009 for putting up construction of ground, first and second floor for the purposes of IT or BT or BPO and for residential purpose. So, the petitioner stated that the construction has been put up in terms of the sanction plan, and therefore no action could be taken against the petitioner. Stop. Learned counsel further submit that it appears that the immediate cause for the impugned notice may be certain directions issued by the Honorable Division Bench of this court in various public interest litigations, including WP number 3676 of 2008 and connected matters. Stop. Nevertheless, since the petitioner had obtained a sanction plan for putting up a construction for the purposes of IT or BP for BPO and residential purpose, comma, no fault can be found with the petitioner. Stop. However, comma, the apprehension of the petitioner is that the respondent health officer may proceed to reject the submissions of the petitioner and cause damage to the building. Full stop. Next para. Statement of objections have been filed.
They've also filed an additional statement of objections where they practically admit that there is no violation. They say that it's a residential mixed area, that the plot size is 371.55 square meters, abutting a road size of 18 meters.
Where is that?
Filed on 4th March 2017.
Statement of objections have been filed at the hands of the respondent BBMP. And additional statement of objections were also filed on 18th of April 2017. While pointing out to the additional statement of objections, learned counsel submits that the respondent BBMP has practically admitted that there is no violation on the part of the petitioner. Stop. In fact, In fact, in the additional statement of objections, it is admitted that a plan was sanctioned in favor of the petitioner in the year 2009. Stop. It is also stated that the petitioner is using the basement bar cellar floor for parking vehicles, and there is no violation of the building bylaws and the terms and conditions of the sanction plan. Stop. The photographs have also been annexed along with the additional statement of objections. Stop. Next para. That being the position, the petitioner is entitled to continue to use the building for the purpose for which it was sanctioned, and to that extent, no objection can be raised by any person or the officers of the BBM. Stop. Next para. This court, having found that the petitioner has put up the construction in accordance with the sanction plan and is using the building for the purposes of IT, BP, BPO and IT, BT, BPO and residential purpose, there cannot be any interference at the hands of the respondent BBM. Full stop. Accordingly, the petition is allowed. The impugned notice dated 28/12/2015 and all further proceedings thereto are hereby quashed and set aside. Full stop. Ordered accordingly.
The objections are mentioned using the basement cellular. There is no basement in the building.
Allah, but our I have repeated that. But I saw in the photograph it was only a stilt.
There is no basement.
On the paragraph. At this juncture, learned counsel for petitioner submits that the plan was sanctioned for stilt ground first and second, and there was no sanction for basement bar cellular parking as has been stated in the statement of objections. Full stop. The stilt floor is continued to be used for parking vehicles. Full stop. Yes. Yes.
Ask me whether NOC is required from the BBMP to construct building for the BBMP to allow construction within 100 years. The same similar matter that Lordship has considered, which is disposed of in the year 2020, based on the submissions made by the council representing the BBMP in that particular case. The petitioners before your Lordship in the present case were the petitioners in that particular case also. Same unilateral matter, wherein your Lordship, the third line of your Lordship's order states the petitioner is aggrieved by the action of the respondent BBMP in granting building license to the respondent number 3 without securing NOC from the petitioners. So that the learned counsel for the BBMP submits that consequent to the interim order dated so and so passed by this court directing the respondent number 3 not to proceed with the construction and calling upon the BBMP to appraise the court in writing whether the consultation with the defense authorities is mandatory for permitting respondent number 3 to construct building, and only after securing the no objection certificate from the petitioner, building license could be issued by communication dated so and so. The BBMP authorities have temporarily suspended the building license granted to in favor of the respondent number 3 till the respondent number 3 obtained the no objection certificate. By virtue of this writ petition was disposed of.
Hmm.
In this particular matter also, it's a unilateral prayer. Your Honor. We have made a representation to the BBMP that the respondent number 3 in respondent number 4 in the present writ petition is also putting up construction within 100 meters as required, where an NOC from the defense authorities is required for the BBMP to grant him with the building license. Our representation is unconsidered by the BBMP. Your Honor. For it, the present writ petition directing the respondents to consider the representation in by virtue of the bylaws as well as the MOD's guidelines here. For that, your lordship had directed me that if any matters are considered by this court on the same line, please point out to that particular aspect.
But there was a bigger judgment that I had written. Where similar type of objections were raised. That no construction can come up within a certain distance. But in that writ petition, held that having regard to the provisions, if a person has already purchased a property in accordance with law, and he is prevented from putting up any construction, then it can be done only after compensating him. You cannot raise an objection. You cannot raise an objection not to permit a person to put up construction because it is right. It is a right enshrined under Article 300A. Every person who owns a property is permitted to put the property for beneficial use. Therefore, if for some reason you want to prevent such a person from putting up construction for whatever reasons, then you are also required to compensate him.
Only submission, my lord, as per my instructions is,
Yes.
the MOD guideline says that if the construction is within 100 meters from the wall of the defense, when a person wants to put up construction, he needs to obtain an NOC from the defense authority as per the guidelines, which is adopted by the BBMP also before sanctioning of a plan.
Where is that? Where is that? If you are saying it is already adopted into the rules, then please point out. Then we will direct them to follow it.
The circular page number 16, Your Honor, at 19, it clearly states clearance from various agencies. 19, my lord, serial number 3. From 1, 2, 3, there are around 7 authorities from whom they need to obtain.
You pointed out to this last time, and we also saw this is under the Karnataka Municipalities Act. This notification is issued under the provisions of the Karnataka Municipalities Act. We are talking of BBMP. Then it will be Karnataka Municipal Corporations Act and now BBMP Act. If you are able to point out to that incorporation of this provision, we will straight away direct them to follow it.
Year 2020.
We have not gone into any provisions of law. It was simply based on a statement made. We have not gone into any provision of law. Now you are asking a direction to be issued to the BBMP that they shall ensure that unless a NOC is obtained from the petitioner, no other person should be permitted to put up any construction within a stipulated distance. That is your request.
Yes.
Therefore, if that kind of a direction is to be given, you will have to point out to the provision of law.
So my instructions is available in the BBMP website itself, is what was instructed to me by my officers. You have to take a printout from that particular and place it before the.
It cannot be simply on their website. If it is there, then definitely provision also will be there.
They instructed me was that when I called them to my office.
No, idunna ನೀವು last time point out ಮಾಡಿದಾಗ I said, see, this is coming out of the Karnataka Municipalities Act.
ಅದಕ್ಕೋಸ್ಕರ ಅದನ್ನ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. But also I was instructed was that it is also available in the BBMP website, wherein many number of such applications day in and day out are placed before our authorities here.
Where is that website? Copy of the.
I personally will take it out and keep it before the court here. Place it before the court. But why this has been made out here? The security reasons is what has been instructed to me. Because parachute regiment is a training center.
There is no difficulty. Yes, we understand.
Where the rifle shooting trainings are given to the jawans here in this particular area. 3 meter ಒಳಗಡೆ ಇತ್ತು ಅಂತಂದ್ರೆ ಮಿಸ್ಫೈರ್ ಆದ್ರೆ ಯಾರ್ದನ ಮನೆ ಕಟ್ಟಿದ್ರೆ ಅಲ್ಲಿಗೆ ಏನಾದ್ರು ಹೋಗ್ಬಿಟ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ ಅನ್ನೋದು is the only apprehension why this was made out in the MOD's notification requesting the BBMP that 100 meters from the wall of the defense, because this parachute regiment center is where trainings are given to the jawans with the rifle shooting. Keeping the public interest at large in mind, this was requested to the MOD, to the local authority that.
Adu ಆಯ್ತು. There is no difficulty. See, those days when all these areas were given to the defense personnel, ಅವಾಗ ಯಾರು ಕೇಳೋರು ಇರಲಿಲ್ಲ ಆ ಕಡೆ. ಈಗ ಆ ಪರಿಸ್ಥಿತಿ ಹಂಗಿಲ್ಲ. For an inch of land, people are fighting. And if they have purchased lands around this area, when there was no restriction, now if you want to put a restriction on the usage of the land, then naturally they will be affected.
What the procedure adopted in MOD is what was instructed to me. I just, for my curiosity to understand, I was just taken.
Idನ್ನ consider ಮಾಡಿ I have written another judgment. You please see that one. There I have clearly held that it requires that statute itself made it clear that you have to pay compensation.
No, I just put so that let me also get myself also
without going into all these aspects. Now ಸುಮ್ಮನೆ ಅವ್ರಿಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಡೋದು ತಪ್ಪಾಗ್ಬಿಡುತ್ತೆ ಆಮೇಲೆ. Valuable rights of people will be lost.
Because this being a training center, if there is a
Also,
misfiring also,
now
that will also affect the
competing interests. They will definitely point out to Article 300A. Therefore, that is why the provisions are incorporated in the statutes also. That if it comes to that they have to be stopped from putting up construction, then they'll have to be compensated.
I just go through that so that the statute also I will be able to. For that reason, I was also.
What you also please find out from your website. Illa, there is nothing. ಅದಲ್ಲ ಹಂಗಲ್ಲ. Not only for a particular piece of property, it's a general prayer that they are making. If anyone comes up with any application seeking a sanction of the plan, and that land is within a certain distance of the compound of this parachute regiment, defense lands, then their NOC have to be obtained. Unless there is such a provision, we can't direct them.
Example, the 7 authorities which are, one is the monuments archaeological department, one is the airport authority, one is the defense authority. Either there are certain places.
Correct. ಎಲ್ಲಾದ್ರಲ್ಲೂ
maintain the.
ಎಲ್ಲಾದ್ರಲ್ಲೂ there is provision for payment of compensation. I have studied that archaeological sites act also. There also the same thing was done. You will have to leave a certain buffer zone. No construction should come up within a certain distance. In those cases, and other than adadmele, you will have to obtain NOC. Andre ಎರಡು ಮೂರು type is the ranges.
In the buffer zone, there are different ones depending upon the drainages. What type of 25 meters?
Sorry. Because that depends on the size of the drain. Illi archaeological sites hangalla. Up to a certain distance, you cannot put up any construction. Adrinda aachege only after obtaining NOC. Athara ide. So in these cases where any sort of construction is prohibited, there is also a provision for compensation.
Restricted area. Restricted area.
Yes.
First area happened to answer one of.
You notice you would have come across
Restricted area. Then beyond the restricted area, we have got a buffer.
So there you
classes permission.
You find provisions for grant of compensation.
Particularly grant of compensation.
Therefore,
archaeological there is grant of compensation for that particular. But in defense statute, we just go through. I have not come across in many of the matters which I have argued before on behalf of the parachute regime. Not come across. Let me also go through and apply research on that before appraising. What I have not studied, let me not make an answer. It may hinder other cases.
the prayer in the writ petition is to direct the respondent BBMP to consider representation dated 11/9/2018 at annexure E2 and take suitable action. Full stop. It is contended on behalf of the petitioner, which is a training center of the Defense Department, that no construction activity should be permitted by the local authorities within a distance of 100 meters from the boundary of the defense lands.
10 meters is our representation. Page number 22.
10 meters,
10 meters.
not 100.
10. Representation page number 22.
10 meters.
10 meters. Now representation is there. 10 meter goes. With the
Without obtaining NOC from the petitioner center. Full stop. Learned counsel for the petitioner is required to point out to any provision of law which would make it mandatory for securing such NOC or any orders that would be binding on the respondent BBMP. Stop. As per learned counsel for the respondent BBMP is also requested to find out as to whether there is any such provision either under the Karnataka Municipal Corporations Act or the BBMP Act. Stop. Since it was submitted by the learned counsel for petitioner that the website of the respondent BBMP contains such an information, learned counsel is requested to find out from the website as to whether there are any such instructions. Stop. Release this matter on 26th of July. ಹಾ ಅದು ಇವಾಗಿಂದಲ್ಲ, ಅದು ಲಾಂಗ್ ಬ್ಯಾಕ್. Please find out. Otherwise, if I get information, I'll pass it on. Yes, all other matters next week.
The GBMP is asking the relinquishment of the property, precondition to sanction the building plan.
Provision. ಏನಂತ?
So it has been held by some court that there is no such provision.
ಏನ್ ಯೋಗೀಶ್ ಅವರೇ ನೀವು ಏನು why are you making this kind of submission? I have told you clearly that there cannot be any law which will take away the ಏನು ಓದಿ, let us see. ಅದಲ್ಲ ನಿಮ್ಮ ಇದೊಳಿ ಪ್ರಾವಿಷನ್ ಓದಿ. Yes.
The land shall be public road and used for access according to the
There cannot be any provision like that. There cannot be any. Sir, Town and Country Planning Act ಒಳಗಡೆ provision ಇದೆ. The same thing may be repeated here. That pertains only to roads, parks. ಅಷ್ಟೇ.
May I read that my matter?
ಅದು ಬಿಟ್ರೆ it is impossible to have any such provision where you will take away the immovable property of a private person without
What he wants to.
ಸಾಧ್ಯನೇ ಇಲ್ಲ.
9 ಅಲ್ಲಿ Roman 9, any roads proposed in the master plan shall be incorporated in the plan, shall be handed over to the authority free of cost.
ಯಾವ್ದದು?
ಅದು ಈ ಕನಕಪುರ ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿ ಇದು. There they have said if it is approved for non-residential layout, if non-residential approval.
ಅದೇ sir, it is in the layout. That is definitely there. It is there in the Town and Country Planning Act also. So only under those circumstances where you have formed a layout and you have formed roads, that has to be given up. It will become a private road, a public road. It will not remain a private road. When once a layout plan is sanctioned, all the roads that are formed in the layout will become public roads. That have to be handed over to the local authority. ಅಷ್ಟೇ. ಅದು ಬಿಟ್ಟು
my matter shall be handed over. Planner ಅಲ್ಲ, master key.
Yes, say, Mr. Yogesh, you please try to understand. Even if such kind of provision is there, it will be struck down in a minute. Please understand.
What I challenge.
ನೀವು ಯಾವ ತರ ಓದಿದ್ರು ಅಷ್ಟೇ. ನೀವು ಯಾವ್ದೋ ಒಂದು ಪೋರ್ಷನ್ ಓದ್ಬೇಡಿ. ಸ್ಟಾರ್ಟ್ ರೀಡಿಂಗ್ ಫ್ರಮ್ ದಿ ಬಿಗಿನಿಂಗ್. ಕೊಡಿ. Let us. Then if they have challenged it, you please be prepared. B. If
1.4.1C approval for non-residential.
one nimsha. If the non-residential layout for approval consists of 2 or more number of plots, the following conditions shall apply. Adar kagade irodidu. So again, it is the same thing. You can't read a small portion. ಯಾವ್ದಾದ್ರಾಗ್ಲಿ if a road is being formed as per the plan sanctioned by the planning authority, if it is shown as a road, it should be given up as a road. Adralli ಏನು ಡೌಟೇ ಇಲ್ಲ. What is the efficacy of section 69 of the Town and Country Living Act? Why? Free of cost. Why free of cost? ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು. You are reading it without application of mind. The entire, you should read the entire provision, sir. Not only that one small clause. ನೋಡಿ 1.4.C is regarding approval of non-residential layouts. It arises out of that. Andre, if a plan is submitted for formation of a non-residential layout, all these things would apply. So it is very clear, it would apply only in those circumstances where a plan is submitted for approval of a layout, whether it is a residential layout or non-residential layout. Once roads are formed in a layout, they have to naturally be given up. There is no doubt about that. Whether it will be in consonance with the master plan, ಅದರಲ್ಲಿ ರೋಡ್ಸ್ ಅಂತ ತೋರಿಸಿದಾರ, ಅದಲ್ಲ ವಿಷಯ. If you say there is a proposed road in the master plan and that portion has to be given up free of cost, it will be in contravention of section 69. ಯಾವ್ದಾದ್ರು ಅಷ್ಟೇ. ನೀವು ಡೆವಲಪ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೂ ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಂಡು ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟು ಡೆವಲಪ್ ಮಾಡ್ಬೇಕು. ಏನು that is not the issue here.
This matter, what I submitted the plan, I have incorporated that area which is proposed, and I have sought for permission to develop it as a single unit plan. He wants, he has issued a notice order. It should be handed over to the field.
Correct.
Free of cost.
ಅಲ್ಲ, ನೀವು ರೋಡ್ ಫಾರ್ಮೇಶನ್ ಮಾಡಿದ್ರೆ, ನಿಮ್ಮ ಲೇಔಟ್ ಅಲ್ಲಿ ರೋಡ್ ಫಾರ್ಮೇಶನ್ ಮಾಡಿದ್ರೆ, ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಗಿವನ್ ಅಪ್.
They are not developing that one. They are not part of the layout.
Of course, it is free of cost only.
ಮಾಡಿದ್ರೆ ಅದಲ್ಲ, ನಂದು ಸಿಂಗಲ್ ಯೂನಿಟ್, ನಾನು ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಕೊಂತಿದ್ದೀನಿ, ಒಂದು ಪ್ರಪೋಸ್ಡ್ ರೋಡ್ ಬರ್ತಾ ಇದೆ, ಅದನ್ನ ಸೆಟ್ ಅಪಾರ್ಟ್. Now it's a pre-construction zone. I'll set it apart. Please sanction my plan for single construction of a single unit in my property.
Sir, he is putting up the building in his property.
Particular roads.
It's a single unit building. It is like any other building.
Apartment.
Allunu kuda, since this kind of a condition was imposed while sanctioning the plan, all of them challenged it, and now it is set at naught. If you try to incorporate anything like this, that you give up your land free of cost, it will naturally have to be struck down. Except a case where a plan is submitted for formation of a layout, roads are formed, parks are formed, CA sites are formed, or ಇದನ್ನ ಯಾವುದು ಇಲ್ಲೇ ಬರೀ ರೋಡ್ಸ್ ಫಾರ್ಮ್ ಮಾಡಿದ್ರೆ yes.
Suppose road in master, we should not develop that land. Another.
You will not Allala, you will not allow them to utilize that area.
We have excluded and start for a second plan.
But at any rate, there cannot be a condition that you will have to give it up free of cost. It is impossible. Therefore,
My suggestion is, ನಾನು entry ಮಾಡಿಲ್ಲ, plan submit ಮಾಡಿದ್ದೀನಿ. ತಿಂಗಳಾಗಟ್ಟೆಯಿಂದ let it be.
all this patch matters. Let it come up day after tomorrow. Serial number 44. Batch matters. Batch matters. ಅದು ಯಾವುದು ಡಿಡಕ್ಟ್ ಇದು ಡಿಲೀಟ್ ಮಾಡಿ 13080. ಯಾರು ಮಿಸ್ಟರ್ ಮಂಜುನಾಥ SB.
I have restricted my prayer only so far as the demand is concerned.
I've seen the prayer.
Free of cost matter.
Prayer annexure A, what is challenging us? There is no demand for.
I read my prayer. Writ of washing up annexure A as far as demanding of relinquishment of reserve road, widening of a road measuring so and so.
ಅಲ್ಲ ಕೇಳೇ ಇಲ್ಲ ಅಂತಾರ ಅವರು.
ನಾನು ಕೇಳಿದ್ದೀನಿ.
ಅಲ್ರಿ ಆ ಡಿಮಾಂಡ್ ಅಲ್ಲಿ ಆತರ ಇಲ್ವೇ ಇಲ್ಲ, ಕಂಡೀಷನ್ ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. Anyway, if that is the case, then we'll see. We will consider.
My lordship.
At 2:30.
My lordship, serial number 42, my lordship.
We'll have it on.
My lordship, serial number 42, my lordship.
24th at 2:30 p.m.
My lordship, serial number 42, it was already covered by the judgment. PBMP has issued notice, demand notice for the payment of the tax for the educational institution.
Education institute.
Serial number 42.
42.
My lord, serial number 2.1 I appear for the petitioner, my lords. It says that notice has been ordered.
PBMP. Yeah, which is that non judgment 4/881 of 2023. Same order.
My lords, 42.1 also, my lords, the same order may be passed, my lords. That is also in respect of educational institutions.
PBMP, same. 42.1 also.
Please, my lord.
Yeah, adralli idu
my lords, it says.
ತಗೊಳ್ರಿ ಅದು ಅಲ್ಲ ರೀ WP number 6192 of 2022 ತೆಗಿರಿ. ಪವನ್ ಕುಮಾರ್ ಅಲ್ಲ ಮಿಸ್ಟರ್ ಮುರಳೀಧರ್, ಅದರಲ್ಲಿ ಆ 2 ಮ್ಯಾಟರ್ ಅಲ್ಲೂ ಮುರಳೀಧರ್ ಅವ್ರ ಹೆಸರು ತೋರಿಸ್ಕೊಡಿ. PBMP. Please wait, sir. ಅದರಲ್ಲಿ learned HCGP for response number 3 state Shri BV Muralidhar for response number 1 and 2 PBMP. Yes.
Petitioner
Bless.
You have to take it, on the right, it's not available yet. The private respondent is going on with this.
You'll have to please wait, sir.
No, it's been this.
ಏನು
Paying to.
ಏನು
Paying on to, please.
ಜಡ್ಜ್ಮೆಂಟ್ ಆಗ್ಲೇ ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಕ್ಟೇಟ್ ಮಾಡಿದ್ನಲ್ರಿ ಇನ್ನೇನ್ರಿ
ಯಾರು ಅವ್ರು confidential ಇಲ್ಲ ನಾವು ಅನ್ಕೊಂಡಿದ್ದೀವಿ.
ಅಲ್ರಿ ದಯವಿಟ್ಟು ನೀವು ನಿಮ್ಗೆ ಯಾವ ರೀತಿ ಹೇಳ್ಬೇಕು ನನ್ಗೆ ಅರ್ಥ ಆಗಲ್ಲ. ಏನ್ ಅವ್ರೇನ್ ಬಂದ್ ನಿಮ್ಮನೆ ಮೇಲೆ ಇದು ನಿಮ್ಮ ಲ್ಯಾಂಡ್ ಮೇಲೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ರೆ ಅದೊಂಥರ ಅವ್ರು ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದಾರೆ. ಅವ್ರಿಗೆ ಕಾನೂನು ರೀತಿಯಲ್ಲಿ ಅದು ಮಾಡೋದ್ ತಪ್ಪು ಅಂತಂದ್ರೆ ಅವ್ರು ಹೊಡೆದಾಕ್ತಾರೆ. ನಿಮಗೇನಂತೆ?
Commercial property ಬಂದ್ಬಿಟ್ಟು ನಮ್ಗೆ ಇರಕ್ಕಾಗಲ್ಲ. Commercial property 3,000 square feet.
ಹೌದ್ರಿ,
ಅಂದ್ಬಿಟ್ರೆ ಮನೆ
ಹಣ ಹಾಕಿ ಖರ್ಚು ಮಾಡಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾರ ಅವ್ರು. ಅವ್ರಿಗೇನಾದ್ರು ತೊಂದ್ರೆ ಆದ್ರೆ ಅನುಭವಿಸೋರು ಅವ್ರು. ನೀವ್ ಯಾಕೆ ಇಷ್ಟು ಒದ್ದಾಡ್ತೀರಾ?
construction complete ಆದ್ಮೇಲೆ ನಾವು ಹೊಡೆಯಲ್ಲ ಅಲ್ಲ.
ಯಾಕೆ ಹೊಡಿಯಲ್ಲ?
Commercial property.
ಎಂತೆಂತ ಸ್ಕೈ ರೈಸ್ ಬಿಲ್ಡಿಂಗ್ ನ ಒಡೆದು ಹಾಕಿದ್ದಾರೆ ಕೋರ್ಟ್ನವರು. ಏನ್ ಹೇಳ್ತಾ ಇದ್ರಿ ಇಷ್ಟಲ್ದೆ?